Sending list give to my court officer.
Urgent wallet mentioning.
May I be saying I have been declared to be a fraud. Sorry for the point.
Who declared you fraud?
That was brilliant. I
Immediately I will take it, sir. If you have been declared as a fraud.
Clients have been declared to be a fraud by the PNB Bank without service of the forensic audit report.
Maybe Lordship's
Mention.
and may I Lordship's kindly to obtain a tender number to move a very urgent urgent motion with regard to a tender matter. Well, what has happened, I have submitted by mid. I am completely okay with the bid. This is on emails, internet. When I submit, they do not give me an acknowledgement. So, on that day also, I went and served a physical copy also. But now I find that they are not considering me. My bid, saying that I have not submitted the bid.
When the last date?
It was last date for opening the bid is on the 6th. It was on the 1st, they did not, they pushed it back. It's on the 6th.
6th of July.
6th of July. So I was only praying.
It is not online.
It is online. But they did not, online I have submitted. But I did not get the glitch. The opening is physical. Submission is on the same day at the same time. Within that time I have submitted that. I also have a letter
Department.
This is the culture department, information culture department of state of West Bengal. If I can move it today or your lordship.
6 is the last date.
Yes, but
Opening date.
But 6th, your lordship knows, could be some.
कल के रख दें 5 मिनट रख कल 5 within 5 minutes. Issue notice.
I will definitely
issue notice.
Well, may I have
short notice.
I'm sorry.
Grateful.
Lordship leave to pray for urgency for the leave. The Pollution Control Board is the petitioner. The Honorable National Green Tribunal has passed an order directing the Pollution Control Board to assess environmental compensation when there is none. And my lord, the burden is that if you don't do it, my lord, consequences will follow. And the on record.
So why you not prepare an appeal?
Because
NGT against the NGT order appeal is there.
Because your lordships have held time and again the 226 is maintainable against the NGT order. But the difficulty is that it is on 6th. I'm not asking your lordship to take it up tomorrow also. I'm asking that my lordship kindly grants me that I will serve. Lord, kindly it appears 7th on the top.
7 within 5 minutes.
I'm deeply obliged.
Notice, serve the notice.
Yes, I'm deeply obliged.
Similar sort of an issue. I have been working for an oil marketing company. I've been giving tankers for delivery of oil. Suddenly, without giving any, a show cause was served. I gave my reply. My reply wasn't considered. No opportunity of hearing given. I'm covered by your lordship's order. Lordship, I'm just seeking, and I've been now.
A new tender has been issued by the IOCL.
No new tender has been issued.
No. I am dealing with the new tenders now.
No. Well, Lordship, nobody has been. Now a threat has been given that my EMD will be forfeited, and I.
What is the ground?
Lordship, the ground.
Not changing of the ownership.
No. Lordship, the ground is that apparently my vehicle was being used in some other place. However, then how was I delivering the? There is no allegation that I have not delivered the oil. They have accepted that I have delivered the oil, but however, they have said that my tankers were being used in some other
purpose,
other place. If I've been delivering oil, how did that happen? I have given everything in my reply. Reply is not a whisper of the word of the things that I mentioned in my reply. Lordship, I am not praying that we take it up tomorrow, at least on 7th.
Come on, at 7th.
8th on top, Lordship.
But you should notice.
Yes, Lordship.
8 within 5 minutes.
Very urgent. Grateful, Lordship.
Very urgent.
Huh? Who is the donor?
My foreman details have failed. This is the urgency. My request is there. The state has rejected the request to undergo the surgery.
Why?
But there is no reason. It's an unreasoned order.
Whether the police verification has been done with regard to the donor and financial condition has been.
Application is filed. All affidavits submitted. The donors father has also different affidavit saying that there is no issue if my daughter donates a to the petitioner's husband.
No, but the donors credibility and all the financial condition, all these things to be taken into consideration. Financial implications of.
That of 1994. If the donor is ready and willing.
That's correct. That's correct. But the other part is to be taken into consideration. Okay. So
But
one.
it appeared on Tuesday at the top. Because when countries and dollar passed by the state, they have only given a chart. 20 patients have been approved. Only my client is the unfortunate one whose request has been rejected.
Ninth
At the top.
within 5 minutes. Issue notice. Without notice, it is not.
Milord,
Notice and
Milord,
come.
with leave of the
Milord,
Milord, with leave of the court, may I please mention?
my lord, this in upgrade motion item number 157. This is a matter where a building's fire license, a gas bank license was not renewed. My lord directed the state to file a report. The report has not come from March. My lord, what has happened on first, they had come to our house and said that they will come on third again to inspect. My lord, if there is no order of not to take coercive action, but if it can be taken up tomorrow, my lord,
Give the mentioning list.
I
Here the.
May I minutes kindly minute. May I minutes kindly to mention Millet, item 460 of the monthly list, Millet. So this matter was appearing as a specially fixed matter, Millet. After the respondents were given an opportunity to file their opposition, they did not, Millet. When the matter appeared for specially fixed at 2 p.m., Millet, they once again appeared and made a fresh prayer for extension of time, Millet. More than 3 months have passed thereafter, Millet. They have not used it, Millet. Whereas, Millet, they are proceeding against Millet, the writ petitioner, Millet. I'm not asking for
What is the matter?
it's a tender matter, Millet, where Millet, my tender has been, Millet, I was working. It was illegally terminated. The rest of the work has been assigned to someone else, Millet. My lord was pleased to hold that I'll hear out the writ petition and dispose it off, Millet. Lawyers, Millet, they did not turn up, Millet. No, Millet, I am only praying, Millet, any date we fix for hearing of this application is really for final hearing, Millet. Any day, Millet, won't take much time, Millet.
But my diary.
Millet, next week thereafter, Millet, any day can be fixed it, Millet.
Wait a minute, fix it. Who is the other side?
Millet, I just have
So
served.
one thing,
I have served.
I am fixing day after tomorrow as to be mentioned.
Very well.
Inform the other side
I'll be
in
okay.
presence of both the parties. Then I fix them. Otherwise,
okay.
then it will be problem.
Very well. Item
Day after
460.
tomorrow to be mentioned for fixing date.
I'm
Inform the other side.
I
Let
shall.
the other side.
I shall. I'm deeply obliged. But that's Saturday. Day after tomorrow is Saturday, Millet.
Tomorrow, no, tomorrow.
Tomorrow. I'm
Tomorrow.
deeply obliged.
My lord,
If my lord, to mention my lord, batch of repetition, my lord, what happened, my lord. Previously, my lord, they are my lord, the doctors. Now, my lord, they have undergone my lord, the master degree. While admitting in the master degree, my lord, they had to depose, my lord, submit all original documents. Now, my lord, they undertook the master degree in command hospital. Now, my lord, after passing out, my lord, they are required to, my lord, government authorities are required to, my lord, return those documents, original documents. Now, my lord, it was not done. Previously, my lord, batch of petitions were moved, my lord. Respondents were notified. Immediately after being notified, before any order passed, my lord, they submitted, my lord, we are releasing. Now, next batch came, my lord. This time, my lord, in the month of February, my lord, direction was given. My lord, they wanted to file a report. Now, my lord, report was not filed. Now, my lord, 12th June, the matter came. Now, my lord, again, my lord, they submitted, we have just been assigned, it may be extended. My lord, extended for 2 weeks. My lord, that is also not done. What happened in the meantime, my lord? Other batch of doctors, my lord, who are about to, my lord, approach this court, my lord. Now they were called, my lord, their documents have been released. When we have approached, where no, your matter is pending, we are not going to release your document. Only these things, my lord, kindly let the matter appear, my lord, to be mentioned, my lord. Let the government stand be, my lord, clear. In respect of others, my lord, they are releasing. We are, my lord, making a mistake by approaching this court.
Tuesday कर दो to be mentioned में रखो. Inform the other side.
My lord,
With my lord's permission, my lords.
Tuesday to be mentioned.
And the verification of those documents will be the July matter. Kindly, if the matter be heard before.
What is the matter?
The documents are needed for the verification.
Have you filed the writ petition? When it is fixed? When is the interview?
Monday.
28th of July, Monday. How is the 28th of July, Monday? Monday is
28th.
20.
Like Monday, because matters can be heard before that.
এটা কাজ করুন ও কালকে এসআইআর ম্যাটার আছে না ওলা ম্যাটার भी कल को रखो.
Grateful also.
With my lord's permission.
Tomorrow 1 p.m. the 30 matters are there. This matter be also listed. Tomorrow
With my
SIR
lord-
matters, huh?
With my lord's permission, may I mention, my lords, under extreme urgency, my lords, I am an MSME entity, my lords may recall on 19 June and 24 June, my lords, had heard this matter, my lords, restraining certain banks and NBFCs from taking any coercive steps. I had made representations under the revival and rehabilitation scheme, my lords. And still, my lords, one of the banks, my lords, has seized my vehicle, my lords, and has also posted the vehicle for selling tomorrow, my lords. The auction is scheduled tomorrow, my lords. I'm praying if the matter be listed tomorrow, my lords, high up on the courts, my lords.
There is not just a
My lords, on 24th June, the order is there, my lords. However, one of the banks is not, however, the
bank.
HDFC Bank, my lords. And
HDFC Bank.
on 24th June, my lords, they had come up, my lords, and had
No,
given the
sir.
undertaking, my lords.
HDFC Bank, the advocates telling that they will not take any further steps.
They had given the specific undertaking, my lords. However, they are proceeding with the sale, my lords. The auction is posted tomorrow, my lords.
What can be done?
My lords, if the matter can be heard, my lords, I have also
Auction notice.
I have preferred a separate application also, my lords. Let the application also come up tomorrow, my lords. With the let the can be taken up, my lords, tomorrow.
कल रखो under कल रखो application under the heading application.
Lord, may I be permitted to make some?
My lords, the same will come up tomorrow, my lords. Grateful, my
urgent
lords. I'm
matter.
so grateful.
Lord, this same matter was appearing throughout the daily list of the previous month under the heading urgent motion 2. Now, my lord, the urgency is that the female petitioner here approached the respondent nursing authority to avail the IVF method under ART Act. Now, my lord, they denied the same on the.
Okay, IVF matter is there. You give the mentioning list.
My lord, kindly fix any
Yes.
that, my lord, on the upcoming.
Lordship permitted.
All the mentioning list.
Lordship
Come under the.
Lordship, this is a tender matter, your lordship. Petitioner completed 70% work, your lordship. Wednesday, 8 July, lordship. Tender was open, my lord. It is very urgent, my lord.
Kindly.
My lord.
Mention
one
one
matter.
matter.
Will kindly
My lord, my lord, can I please mention a matter, my lord?
My lord, this is a matter. I am item number 1.
My lord, can I please mention, my lord, one matter, my lord? My colleague has mentioned, my lord, that matter, my lord. May I please?
My lord, I am. For the item number 1, respondent bank lordship. My lord, I am for the petitioners.
The so-called notice dated 25th of December 2025 is set aside and caused. However, this order will not prevent the bank for taking appropriate steps against the petition in accordance with law. It is further made it clear that if the bank intending to rely upon the forensic audit report in future, the bank may request the auditor to obtain all necessary documents from the liquidator appointed by the tribunal or from the DEO to conduct forensic audit report to come to a definite finding. The petition also directed that if any request is made by the auditor for supply of any documents and the petitioner possesses the same, the petitioner shall forward the same after being verified by the liquidator.
Grateful, my lord.
Yes, 2. This I have dismissed. All other 3 are dismissed because the so-called reply you have make out another case. You have not prayed for any document or forensic report. Other 3 have been dismissed.
My lord.
Next.
Item number 5, lordship, on behalf of the petitioner, I have received instructions to withdraw this matter as not pressed.
Give. Your instruction.
Yes, lordship.
And the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for withdrawal of the writ application. Counsel for the petitioner handed over the written instruction, wherein the advocate, the petitioner informed the advocate that the petitioner is not intending to proceed with the matter. Consider the submission made by the counsel for the petitioner, peruse the communication WPA number 17592 of 2021 is dismiss as withdrawn. Communication be kept with the record. Next.
May it please your lordship, my lord, I am on behalf of the petitioner, my lord, for withdrawal, my lord, I have the written instruction.
Net counsel appearing for the petitioner bank.
Thank you.
Bank.
Canara Bank.
Submit that he has instruction from the bank to withdraw the instant date application according full stop. Ferdinand counsel for the petitioner peruse the written instruction WPA number 8 of 2025 is dismissed as withdrawn. Communication be kept with the record. Next,
Wait for the bank, my lord, same.
same order. 8 also.
8 also, my lord, 9, my lord.
8, 8, 9, 7, 8, 9, same.
Much obliged.
Next.
Very.
Yes, all are appearing.
My lord, all are appearing. My lord, it may come back to your lordship. It's been a long time though. It will come back to your lordship, my lord. In fact, your lordship had heard this. I'll tell your lordship, my lord.
No, who is appearing for the state? Government paid.
State, they are appearing. In fact, my lord, we have to deal with the affidavit which has been filed by the Public Enterprise Industrial Department, Government of West Bengal. I stand corrected, my lord. Public Enterprise Industrial Reconstruction Department, Government of West Bengal.
That is the, nobody is there.
Nobody. Well, the rest of the respondents are effectively, they are proper party, but effectively it is the
One.
respondent.
One,
In fact,
one.
if your lordship recollects, well, this is an industry which was taken over by the state government under the Industries Development Regulation Act of 1951. The government could not run it. Well, thereafter, well, the government entered into, well, then the company was called the West Bengal Chemical Industries Limited. Initially, at the time of acquisition, it was called Dr. Paul Lohmann India Limited. Well, this company manufactures life-saving drugs. The only industry in the state of West Bengal. So, well, thereafter, well, there was a land which was allotted in the year 1965 when the state government was running the company under the Acquisition Act. 100% shareholding was taken over. So this land at Durgapur was given for a period of 60 plus 30 years to the government. So government could not run it. So thereafter the government, they got into a scheme by which they wanted strategic partnership of private individuals, and thereafter two agreements were entered into, one joint venture, one share purchase agreement. In terms of the share purchase and joint venture agreement, 75% of the shareholding was transferred to the strategic partners.
What can be done? State is not here.
I'll just indicate what is the problem here.
Yes, shifting.
Shifting to Durgapur. Now, unless I shift, because of the urban development, urbanization of Lake Town were the original unit. So pollution control board has told me that you shift your unit. I want to shift my unit.
But the authority of Durgapur is not allowed.
Is sitting over it. So basically, it's the industrial policy of the state. The previous policy of the state was destructive. So they did not want any industry for whatever may be the reason. This is the only life-saving drug company. Portion of my industry have already shifted to Gujarat. So we are trying to save the remaining.
Yes, madam. What report?
Oh.
All the things are there.
May I just say this, madam? I can give in order to expedite the process, I can give the entire pleading, their reports that they have filed to my learned friend. She can take instructions so that it can be disposed of.
Deception. I think might be now the government will change their stand.
Yes, they
It
should.
is a prayer. Take the proper instruction from the government, whether they are Only for shifting, for allotment of some portion so that they can see.
So it was their company, they have brought me in. They were now,
Learned counsel for the respondent number 1. Submitter is not having the brief and he prays for time. Accordingly, the petition is directed to serve the copy of the writ application along with all documents and the reports to the learned counsel appearing for the estate by tomorrow.
shop service করেছো,
By
ওটার
tomorrow,
copy,
learned counsel for the estate is directed to take instruction.
না copy লাগবে,
Let the
copy,
matter appear.
এগুলো কি?
How much time? Within 2 weeks, 1 week? Let the matter appear on
কোথায় গেল?
16 July under the same heading.
My lord, instead of 16,
Yes,
my lord, could it be
20,
17th
17,
or whatever, my lord, or 22nd or 21st, any day,
22nd July.
22nd,
22nd July, take note of it.
22nd. Very well, deeply obliged. Grateful.
I beg to appear to the petition.
Yes.
My lord, this is that passport matter, my lord, I mentioned before your lordship yesterday. My lord, what has happened in this case, the petitioner and her daughter entered India lastly entered India on 15th June 2025. Her visa was, my lord, up to 8th August 2025.
Yes.
However, my lord, there was some delay. I would be very honest, my lord. There was some delay in initiating the application for renewal because, my lord, she's a cancer patient. So, due to her medical issues, there was some delay and she initiated her first application for renewal on 3rd September 2025, which my lord shall find in my supplementary affidavit, my lord, page 9. That's the first application, my lord. She uploaded her respective documents, my lord. She applied for her daughter as well. There was a penalty of 10,000 charge, my lord. While she initiated the penalty for her daughter, my lord, she was instructed and suggested by the FRRO to defer her payment for a while till her daughter's visa is renewed. Subsequent to that, my lord, she did not get any notification whether that application was closed or whether what happened as to with the first application of her on 3rd September 2025 while her daughter's application was renewed. So, finally, my lord, she did her second application on 12th April 2026. That, my lord, shall find on page number 12 of my supplementary affidavit. She was intimated of a penalty of 2 lakhs. That was intimated over the portal, my lord, on the FRRO website.
Yes.
However, my lord, while she made multiple representations before the FRRO for reconsideration of the penalty amount since she had some financial issues. However, my lord, 1 day prior to initiating the application, the writ application, my lord, that same amount turned to 4 lakhs. That I have annexed, my lord, in page number 78 of my writ application. That same amount turned to 4 lakhs. There is no breakup provided. I have the notification, not my lord, the breakup that is provided in the FRRO website. My lord, but it is kindly see page number 78, my lord.
All the instruction is.
Lord, I'm led by Mr. Amit Ranjan Potiman.
Well, look, my prayer is very limited. The amount goes to hike to 4 lakhs without assigning any reason.
No, they are telling it inadvertently and you have to pay the 2 lakh rupees.
Yes, because my lord, even if it is at 2 lakhs, my lord, kindly take the slab. It says that if I'm, because my lord, first of all, let me clear before your lordship that I have not entered India illegally. After passport, my lord, visa, every procedure completion, I entered. Then subsequently, my lord, my daughter came, her entire documents have been, my lord, regularized. Then I, my lord, suffered, my lord, cancer, and for which I am under treatment over here. Then, my lord, according to them, the slab is that if I am overstaying India 1 to 15 days, fine amount is nil. And then if it is 1 month, its amount is 10,000. If it is 60 days, slab is, my lord, 20,000. But the language used in the slab is that 90 days above is maximum amount is 50,000.
Correct.
Now, my lord, 2 lakhs, according to, subject to correction, my lord, according to my understanding, that 90 lakhs, 50, my lord, 2 lakhs, they are charging like this. Suppose, my lord, I am staying of 10 months. Each 3 months they are charging. So in that way they are charging, because, my lord, I am completely unaware that how they are charging. Because if I go by their slab, subject to correction, my lord, my understanding is that they could have charged me 50,000. Because above 90 days, my lord, as like, my lord, in a criminal my lord, jurisprudence, as we get to know that sentence, minimum sentence is there and maximum sentence is there. So the language used in the slab is that, my lord,
Where is that?
my lord, the slab
Fifth page
is,
of the
my lord, that
1 day to 30 days, 10,000 rupees.
10,000.
31st to 90 days,
20,000.
20,000.
Now, my lord,
91 days to
91
180
1
days,
50,000.
50,000.
And then
180 days
180 days, 1 year, 1 lakh.
to 1 year.
So, my lord,
More than 1
assuming
year, 2
I am
lakhs.
staying, according to my calculation, 10 months.
So your visa is complete,
My lord,
expired on
my
8th
last,
August.
last visa expired on
8th August.
2025.
Correct. 8th
Yes.
August
My
2025.
first application for extension is on 3rd
3rd
September
September.
2025.
3rd September.
Subsequently, my lord, that application, my lord, did not responded by the authority, responded to the by the authority. So, my lord, the application expired.
So
Then
first,
in,
yes,
but
first 30 days the 10,000. So 8th August to 8th September 10,000 rupees. Correct.
assuming, my lord.
Correct. Now thereafter,
Then, my
now
lord, thereafter,
then
fresh
31st to 90 days, 31st days to 90 days. So 9th of August, 9th of August onwards, 9th of August onwards of 10th of October.
October.
10th of October, then 90 days, 1 month. Then 10th October to 10th November.
My lord,
10th,
cut short the matter. My lord, my visa expired on 8/8/25. I am starting calculating from there. Now 8/8/25 till my second application, because first application, my lord, there is no result. My second application is of 12/4/2026. So, my lord, according to my calculation, 8 months.
12/4?
12/4/2026. So according to my calculation, my lord, it's 8 months. 4 months there, and subsequently this, my lord, 4 months.
8 months.
8 months.
4 for 8.
Then, my lord, first time they charged me for 2 lakhs after 12/4/2026. Though, my lord, in the server, my lord, the no specific date is being mentioned. Once the documentation process is complete, then that payment, my lord, structure will come.
Okay.
Now, my lord, if I assuming that till today, that is, my lord, June 2026, it's supposed to be 10 months. My lord, 10 months, if I take the last slab, 181, 1 days
81 to 180 days.
181 to 1 year, my lord, last slab.
Last is a 1 lakh rupees.
Yes.
180 to 1 year,
180, my lord, supposed to be 6 months. Then 1 year.
So 8
I
months,
am-
yeah, 1 year.
1 year, my lord, it's supposed to be 1 lakh, subject to my correction. But still they are charging me 2 lakhs.
Yes.
There my case lies.
Yeah, I have gone through, but yes, kindly come to the page 4, paragraph 4. See, applied on 3rd of September 2025. However, the visa expired on 8th August 2025. A penal fee rupees 10 is registering was requested for further processing of first. But now the 2 lakh rupees, how? If you go by the slab, if you kindly come to the notification which you next page and page 2.
Work stay by the foreigner beyond the validity of the visa period.
Yes.
First duration of work stay, that up to 30 days, 10,000.
10,000. That is
1 to 90 days,
20,000.
20,000.
And 91 to 180 days,
180 days,
50,000.
50,000. Then
And
181 up to 1 year, 1 lakh.
1 lakh. So here 1 year has not yet completed. How the 2 lakh has come? More than 1 year, 2 lakhs rupees will come. So how the 2 lakhs rupees has come? How they have calculated?
Let's get further instruction. One day of this.
Take.
Well, one thing they will assure that they will not take steps against me, my lord, because I'm ready to pay.
Matter is pending. If they step, I am here.
Great. And, my lord, let the matter be written in the same.
The
Grateful.
The Senate Council appearing for the Passport Authority has submitted the report and submit that the petition is required to file and required to pay rupees 2 lakhs for overstay from the validity of the visa period. Learned counsel for the petitioner raised disputed with regard to the payment of rupees 2 lakhs, and he has brought the attention of this court to the schedule with regard to the overstay by the foreigners beyond the validity of visa period. And as per this set schedule, if the foreigners overstay more than 91 days up to the 180 days, more than 181 days up to 1 year, the penalty should be 1 lakh rupees, but the respondent authorities have are directing the petitioner to pay rupees 2 lakh rupees. Then consider for the hospital authorities press for time to take instruction in the matter. According cases adjourned, let the matter appear on 7th July under the same heading within 5 matters. Affidavit service kept with the record. Yes.
May it please your lordship, I am for the petitioner, my lord. This
Yes,
is the,
what has happened?
my lord, I
What
believe
your
this,
bank is doing? Who is for the state? Who is the state? You are appearing for the state. Difficult.
my lord,
I think I will take leave for 1 month. Let the state settle their advocates.
my lord, in this,
That's why subsequently, what has happened till date? That's why you kept the matter. Yes, madam.
my lord, my
You are
lord,
the third advocate appearing now for the state. Only you have to now. Otherwise, I will call the investigating officer with the case diary. Now,
my lord.
only I wanted to see how the investigation is progressing.
Lordship. Lordship, in this matter, since my learned friend is appearing for the Union of India UIDAI, my lord, may they, because it is an Aadhaar issue.
No, that's a, if the investigating officers submit that they are not getting, then I can direct the union.
Lordship,
Of India. That's why
lordship,
I wanted to hear
lordship,
the state.
lordship.
If the state will say the union is not giving or the bank is not giving, then the court. That's why I kept this matter without disposing. I know what will happen. That's why let the what investigation is coming on. What is coming on during the investigation, whether that is fake or whether that is the person, whether the person has been apprehended or not.
Lordship.
If the person has been apprehended, then the surface acts to be closed. Then he can
Lordship.
get the benefit of that. Kept pending. Give one copy to. You are having the copy, writ petition?
Lordship,
Give.
we'll make a copy and serve.
Okay. Learned counsel for the state Samindra is not having any brief in the matter. And Samindra, if the copy of the writ application along with the documents are sought to the learned counsel appearing for the state, she will take up the petition. Accordingly, the petition is directed to serve the copy of the writ application along with all documents to the learned advocate appearing for the state. Full stop. The state is directed to take instruction from the investigating officer with regard to the stage of the investigation, and the investigating officer is also directed to appear before this court along with the report on the next date fix. Leave the matter on.
Lordship, also the petitioner be directed to serve a fresh copy upon the state.
Directed.
Lordship.
On 16th July under the same heading.
Lordship, may I be permitted to have a longer weekend?
Then? When?
This week.
This week? But they will not, that is the problem. No? They will also take, that's why I given 2 weeks time.
Grateful, grateful.
Hello, this is my.
Yes.
The 13 I appear for the respondent number 9.
Yes. Why you are in appellate side?
I'm having a side.
but this repetition is not maintainable.
Why? What is the prayer? What is the prayer?
Milord, first of all, this is a direction, Milord, sought upon the Milord, the respondent number. I'm just coming.
Let the matter be released from the. What is the case about?
Milord, this is a case, Milord, where the defective car was registered.
Yes. So go to the consumers forum.
They have
Milord,
already gone.
Gone.
Yes.
Milord, first of all, Milord, why this application has
What
been.
the red court will do with regard to your car and with regard to the defects in the car?
Milord, only
How the red court will
only
ascertain?
RI can always, Milord, that is respondent number 11.
So what is the prayer against whom?
Milord, against the respondent number 11, Milord, the respondent number 11 can always check the car and Milord, also Milord, redress the grievance of the petitioner.
Respondent number 11. Who is the respondent number 11?
That is Automotive Research Association of India carrying its business.
Yes, you make an application before the forum for appointment of the expert. The Consumers Forum will appoint the expert.
The
and
REIT is
submit the
also
report.
maintainable. Milord, Kishore Mutkar Pingalakar versus the Automatic Research Association. Milord, this is the order passed on 10th February 22, and this is their lordship, Honorable Justice Milord Bela Trivedi and Sanjeev Khanna has already, Milord, affirmed, Milord, that the REIT is quite maintainable against the direction.
If certainly if there is no consumer forum complaint, there is.
This is, Milord, as because, Milord, my SCC online is not working, Milord. This is an India Kanun document.
India Kanun, we don't know what is the.
Yes, it is a reported, Milord. It is also reported in SCC.
Why you not such with the reported judgment? India
But,
Kanun, we don't know.
I will
Not might have been strike off.
Yes, I will supply, Milord. Let the particular online is restored, Milord.
Which paragraph you are relying upon?
Yes, I am coming. Milord, kindly come. Let the matter be made cut short, Milord. That paragraph 22. Learned counsel for the appellant relying upon the paragraph number 13, 32 and 33 of the decision authored by N. Santosh Hegre in G Film Telefilms Limited versus Union of India and others. 15 submits that the association in performing the public function thus would be amenable to REIT proceedings under Article 226. In our opinion, the nature and function performed by the body may be relevant to the Article 226, considering the language of the Article 226, which that is, Milord, that particular judgment it is reported in SCC 15 2005 volume 4 SCC. So, Milord,
no, this subject matter is something else. There, that is only against the automotive company. So court has not entered, but here is the private dispute. You have purchased the car. Your car is defective.
when
your car is defective, you file the consumers forum. You take appropriate steps before the consumer. How the REIT court can go into all this? Otherwise, we will close the consumers forum and we'll set up a one REIT application with REIT court before this.
Unit 2 before.
Not gone to the forum. Had it been the case that they have not gone to the forum?
Where is the forum? Where is
P6. My lord, P6, my lord, kindly come. I do not have the annexures.
Cannot connection नहीं करना. Milord, that is the consumer forum. Milord, the orders are starting from 102, page 102.
Yes.
And Milord,
not appearing. Complainant is absent. Without steps.
But in the next date we have appeared.
Today is fixed for acceptance of the WV.
Yes.
Besides the adequate sanction, the on close scrutiny.
This is not even progressing before the learned forum also.
You pursue the forum. Why you
and Milord, liberty may be given to apply before the forum for the particular expert opinion.
What liberty? Already with you. Already with you. What liberty? You file it. If the forum not allowed, then state forum is there. Not the High Court also. State forum is there.
But my argument is this, Milord. This is against the RI, Milord. The REIT is maintainable, Milord.
Against the RI, it is maintainable. That the Supreme Court. That's why you have gone through this.
Yes.
But here, what is your case here?
Case is
you have purchased the car.
Yes.
From agency.
Yes.
from a dealer.
Yes.
Correct.
And dealer is
after
also,
the purchase of the car, it is found that the car was defective.
yes.
You inform to the dealer.
Yes.
Dealer has not
Rectified
rectified
the
that.
entire thing.
Rectified that.
Right.
Then you made a case before the consumers forum. Now you're telling that without, unless and until you make an application before the forum for appointment of expert body for
Yes.
to see whether it is the manufacturing defects, whether the defects which has already been cured or not. This is the question is to be decided. How the writ court can do all these things, sir?
Milord, writ court can assess, Milord, even Milord directing.
You want to argue the matter? I will
Milord,
hear
no.
the matter and argue. Argue. I will
Milord,
hear you.
I will not, Milord.
Yeah. Argue the matter. I will decide the matter on merit. Argue.
Milord, kindly dispose of this writ petition, observing that the necessary application to be made before the learned forum. No, sir. Where? Where is it? Okay.
The grievance of the petitioner in the present date application that the petitioner had purchased Kia Sonet car bearing registration number WB02AU 2953 from the respondent number 8. It is the case of the petitioner that the car delivered by the respondent number 8 is a defective one. And when the petitioner has taken the said car to the workshop of the respondent number 8 on 22nd of September 2022, informing about the defects in the said car, the respondent number 8 has not rectified the defects, which is the manufacturing defects. Accordingly, the petitioner has made several correspondence with the respondent, but the respondents have not rectified the defects of the car delivered to the petitioner. And he prays before this court for a direction upon the respondents to investigate against the respondent number 7 and 8 and 9 and to take appropriate steps against the respondent authorities. The Learned Counsel appearing for the respondent number.
Hello, I am appearing for respondent number 9, finance company.
Respondent number 9 submit that the writ petition is not maintainable. Writ petition is not maintainable, and the petitioner has already initiated the proceeding before the District Consumer Dispute Redressal Commission, Kolkata -2 within bracket center. He further submit that instead of proceeding the matter before the Consumer Dispute Redressal Commission, the petitioner has filed the present writ application. He prays for dismissal of the writ application. Full stop. Now, counsel for the petitioner submit that the petitioner the writ petition filed by the petitioner is maintainable in view of the judgment passed by the Honorable Supreme Court in civil appeal number in the special leave petition within bracket civil number 6637 of 2019 within bracket Kishore Madhukar Ping Liquor versus Automatic Research Association of India, and submit that the Honorable Supreme Court has held that the writ petition is maintainable against the Automatic Research Association of India. This court find peruse the judgment relied by the petitioner. This court find that the case in the case referred by the petitioner is against the Automotive Research Association of India, and the Honorable Supreme Court has held that the said authority is functioning, is performing the public functions, and as such the writ petition is maintainable. But in the present case, the main grievance of the petitioner is against the respondent number against the respondent number 7, 8, and 9.
7, 8, and 9.
7, 8, and 9, who are the private body from which the petitioner has purchased the car, and after the purchase of the car, petitioner came to know that the car which has been delivered to the petitioner is defective one. On the other hand, the petitioner has already initiated the proceeding before the Consumer Dispute Redressal Forum, and as such, this court find that the writ petition is not maintainable. Accordingly, writ petition dismissed. However, the dismissal of the writ petition will not not affect the proceeding pending before the consumers forum and the petitioner liberty to proceed with this, with the proceeding initiated before the consumer dispute redressal forum.
And my lord, kindly grant the liberty that you will apply, my lord, an application.
Liberty is not required. If rejected, you come.
I'm appearing for the petitioners, your lordship.
My lord, I appear on behalf of the bank.
Yeah.
Lordship, this is the matter which has been filed by the husband and the son against the mother of the petitioner number 2, that is the son.
Husband and son has filed the petition against the mother.
Yes, your lordship. The reason being,
What
the reason,
yeah.
the reason being, your lordship, the husband was maintaining a bank account with the banks before marriage. After the marriage took place, the husband had joined his wife's name as well as in some accounts his mother's name. And after this marriage, they have now a 16-year-old son who has scored really well in his board exams. Now, after this, the wife, what the wife has done is the wife has sent a one-letter intimation to the banks requesting that all the bank accounts and the FDs be freezed. On the basis of such representation, all the bank accounts and all the FDs have been freezed. The wife has also filed a section 125 application where she has mentioned in her affidavit that she is a housewife and she has been a housewife. So the source of income on account of the wife is questionable. Now what has happened, your lordship, the son now needs money for his higher education. He has scored even well. Sorry, he is now pursuing his JEE advance. So he now needs money. Now, if all this money which the father has saved for the son's education, for his mother's illness, as well as for him and his family, if that goes up freezed after the son reaches the age of 16, then it's very difficult for him to go with his son.
So
Now,
what is the prayer here?
Prayer, your lordship, that the reason why the bank has done so.
What is your prayer, sir?
Defreezing of such accounts.
If there is a dispute, how the bank will act? It is a joint account.
The account is not joint, your lordship.
Account
The
is joint?
FDs, the FDs.
FD.
FD.
FD has not been releasing.
Yes.
Bank account is functioning. It is operative. Bank account is
Bank account is in my name.
that is operative.
No, that has also been freezed.
How? Who is for the bank? In whose name the bank account is there?
Yes, my lord, but your lordship's pleasure on the last occasion was to direct me to take an instruction and report.
Correct.
My lord, the report is not in the form of affidavit, but what I find, my lord, there are the operation mode which I insisted, which is proper to indicate before your lordship. Both survivor. Either or survivor.
Correct.
And the other fixed deposit goes in this way.
Correct.
So, my lord, in this way, lordship will appreciate, my lord.
No, either a survivor will come with regard to the joint account.
Yes.
If the account is in the name of the petitioner, as per the submission made by the counsel for the petitioner, is submitting that though the fixed deposit in the name of both husband and wife, but the account is only in the name of the petitioner. If the single account, so either and survivor does not arise. Does not.
This thing doesn't.
Correct.
It will be, my lord, the another term goes is the former or the survivor.
Correct.
For the purpose of operating.
Operating, yes.
But here it is indicated this account holder name is Devagopal, Devipal and Vijitapal. And the other also goes in Vijitapal and Devagopal side. And now, my lord, lordship will appreciate, my lord, we are on behalf of no one. We
Correct.
ensure the money is secure.
Yes.
That we have seen that the, my lord, credit is there, everything has been free. Now, my lord, this was a mandate. If we go by that, my lord, I need not, my lord, say it before your lordship. The mandate was anyone single or survivor, and 1% opts out from the mandate. So, my lord, probably for that reason it has been, my lord, freezed. And if your lordship directs something, my
So
lord,
that's why you have to give the report in whose name the account is there.
This is on page 7.
No, the page 3 kindly come to the particulars of the account, page 2, last line, paragraph 2, particulars of accounts. The details and accounts are maintained jointly in the name of Devabrata, Devipal and Rajita. Are set out in the separate sheet. Where is that?
That is in page 7.
Page 7. Account holder Devabrata. How many accounts are there? 1, 2, 3, 17 accounts.
Term deposit.
17, including term deposit.
Term deposit and.
So which account has been freezed? Which account is freezed?
Whatever has been mentioned there. all
You
has
might have been given the details. Which
Lordship,
account is
page number,
freezed?
it starts from page 8, paragraph 13.
Page 8.
Page 8, paragraph 13, and it continues.
Account number 65. No, let me first. 20385. 20385,906. This is a joint account 91. Saving account, the one number 1 account. It is a joint account. Devabrata Paul, Devi Paul, and Rijita Paul. Correct.
My mother, one is.
Just a minute. And second is 50116. That is also Rita Paul and Devabrata Paul.
Even also mentioned.
There's also joint account. All are joint.
Lordship, these are all.
All are joint. What is the report the bank has
Lordship, the
submitted?
fixed accounts ends with 1906 and 4116. And the FDs which have been mentioned, there
There are
15
two saving accounts. As per your case, as per the case of the bank also. Report. Two saving account. That is 1906 and 4116. They are the saving account and the amount is lying is 749 and 4817. Correct. And both are the joint account. So either a survivor, any single or survivor.
Lordship, the lady has also filed a section 125.
Just a minute. I am not going into that. Let this matter be settled now. So saving account is joint one. So joint one of the account holder may make a report to the authority. The bank has kept the bank as a lien, not allowing to operate. Now, with regard to other, all are the term deposit. The term deposit is also in the name of all joint. So how you can utilize unless and until you get the declaration from the court, civil court, not by the
That
writ
will take a
court.
lot of time, your Lordship, and
initially these accounts were open solely, after that she was added. I'm not, there is no forms with regard to that. What had happened, pointed out, that with regard to the minors' education purposes, this money were presently required. Now, on the first occasion when this matter was moved, my lord was of the opinion that take your proportionate money out and utilize it.
I came to know this is all the term. Now the report has come. Report is something else. All are joint accounts.
Yes, all are joint accounts. I admitted that in the writ petition as well as in the first course of hearing.
Correct.
I admit
What is the name of the son?
that is a petitioner number 2.
What is the name of the son?
Yes, my lord. The name I'm pointing it out. Master Arohan Paul.
His name nothing.
No, it's not his name. It's the name of the mother of the petitioner, the wife of the petitioner, and the petitioner.
Correct.
These are the names.
Correct.
Now, my lord, with regard to these three accounts, my proportionate share of 1/3 share is mine. Let that be utilized for the purpose of the child. Let that much be utilized. I'm not paying for anything which is more than mine.
27 of the writ petition. Who's made the complaint? No, that is not. I am not on that. The court is not going. If you are telling it is a 3 names: husband, wife, and who is mother's father. The husband's mother.
Husband's mother.
Husband's mother. 3 names. Correct. Your name is also there. You might have been because what is the name that you will get? So they are telling that the 3 names. He wanted his amount is to be given to the son's study. Huh? Why? Settlement.
After 498A, after 125 pending for 2 years, after seizure all been done, the bank account lockers are seized. After that, this is the submission, the mediation. And the child is suffering along with the child has been left by the mother.
But what the husband is doing?
The husband's medical representative and the child is residing with the husband, father.
So
Where is the bona fide?
with regard to the education of the child, you are admitting that your wife is working. She is a working lady. Whatever it may, part time or not time. Initially, you started your argument that the wife is working.
Part-time fetches more income than regular these days.
Whatever falls from your lordship, we'll abide by that.
Correct.
I have got
So,
nothing to determine.
whatever, but mother is there. Okay,
Even the mother is there, my lord. I shall.
Sending it to mediation. What can?
But in the meantime, let some money, let otherwise the child's education I cannot afford anymore, my lord.
Why you not file the suit?
The suit with regard, well, I'll have to
You
file.
can file a suit, get an interim.
The declaration, I'll get a declaration with regard to 1/3 share. It's already there. I'm not praying for anything more than what I'm entitled to.
We don't know. Tomorrow they will come. Now this is the time. If suppose now initially he has stated that she is working. If tomorrow she will file the document that okay 20,000 is there, but order 20,000, I have paid 15,000. So how? So she may dispute. She may dispute. So how the Red Court can decide that?
With regard to what has fallen from the lordship, with regard to the future involvement, my lord, if I don't pay with regard to any order passed in 125 proceedings or anything, my lord, there is provisions for. There's other provisions for execution of that.
That is different. I am not going into the now. Last occasion I was, but now the wife is appearing, and as per the report of the bank, all the not only the wife and husband, the mother-in-law is also involved in
That is the case also in pleading also.
Correct. Mother-in-law is also involved. If the mother-in-law also involved, today the court may say, okay, 1/3, but tomorrow the wife will come with say, no, I am the working lady and this is the deposit slip. Out of 20,000, I have paid the 15,000, I have paid the 30,000. Then how it can be decided? How
I've given the entire deposit slips with the TIT application, my lord.
The petitioner has filed the present writ applicant. It is fine that this is the this court find that the matter is to be referred to the mediation for settlement between the petitioner and the respondent petitioners and the respondent number 6 and 7. Accordingly, the matter is referred to the mediation. For instance, the secretary mediation is directed to appoint the mediator and to file the report within 4 weeks.
Grateful, my lord. I'm extremely grateful.
My lord is disposing of.
No, so it has to be
My lord is
returnable.
disposed of.
Yes.
It is pending.
Well, it has to be returnable because the report has to come, my lord.
If it is settled, it is settled. It is not settled, then the court has to decide.
Will the bank be
You
involved?
take this and get it affirmed.
Will the bank be involved in the mediation?
No,
We are doing it not. My lord.
then they will need all the parties. The mediation center issue the notice.
These courts
I'm
are
next.
also decided in this. Bank is not responsible.
Yes, next.
Grateful, my lord.
But I appear for the petitioner. I appear for the petitioner. 1972, Miller, there was a time, Miller, when the central government had introduced a Swatantra Sainik Samman pension, Miller, and that was, Miller, to be awarded, Miller, those who had rendered their, Miller, youth and life, Miller, for the sake of the country during the time of independence struggle. Now, Miller, what happened, Miller? 1980, Miller, the government had come up with another scheme in superstition and or modification of the, Miller, the earlier scheme. Now, Miller, my father, Paresh Chandra Bagh, was, Miller, Sharad Chandra, Miller, he was awarded with this, Miller, the Tamrapatra, Miller, and your lordship will be pleased to find that all those who have been blessed with this by the government, Miller, all who had been awarded, Miller, this Padma Shri or Maranottar Bharat Ratna, all these things. But according to my learned esteemed senior friend, these, Miller, are not relevant, Miller. Assuming not admitting, Miller, these are not relevant, Miller. That, Miller, thereafter, Miller, my mother used to, Miller, receive the pension. Thereafter, Miller, I, Miller, claimed. Now, Miller, petitioner was rightfully granted the family pension for a way. Now, my lord, this is my bank passbook, which depicts, my lord, that thereafter, my lord, I also, my lord, received, my lord, the pension.
You are the daughter?
Yes.
It is the daughter?
Yes, yes, Benu Bag. Now, what happened? But I secured employment as an assistant teacher, my lord. Then I did not do the Swatantra Sainik Samman Family Pension, paragraph page 46, P10. This is the date, my lord, 1999. I secured employment as an assistant teacher, and my lord, I stopped, my lord, withdrawing pension on and from that date. This party, my lord, that I retired from, my lord, the service, my terminal salary is what the option is to find page 47 to 53. My lord, this amount is, my lord, important for deciding the list between the parties. The amount is for 14,517. One, my lord, got it? Page 47 to 53.
Yes.
Now, my lord,
Where is the amount?
the amount,
750?
yes, I'm giving, my lord, I'm sorry. 14,000 to go there. Page 50, my lord. Your lordship, will you please to find at the bottom, my lord?
Yes.
The last bottom, lord,
Yes.
and then, my lord, great pay, sum total is, my lord, 14,570.
As a pension?
No, the salary. I was not entitled to get pension because I did not, my lord, attend the qualifying service. That is why, my lord, there is a, my lord, I said that I did not receive pension because I could not, my lord, because it requires, I did not complete, my lord, 2 years of service, which is evident from the letter of the service book, page 53.
You got the job?
1999. Yes.
Father died?
Father died, my lord, 10/6/89. 10/6/89.
Then mother started.
Yes, and I also
When
started
the
receiving.
mother expired?
Mother expired 1995, 29 December.
95.
Right.
So 95 to 99, the pension was not released in your favor.
Yes, petitioner was rightfully paid. I was, my lord, that for 4 years, I was dependent daughter. I used to receive the pension. Up to October 1999, I received the pension.
October 99 till the appointment.
Till the appointment. Now, my lord, I could not secure, my lord, the qualifying
When you
service.
retired?
I retired 2007, 30th June.
30th June 2007.
7. Yes, my lord.
So now you wanted to cut.
Now, my lord, I submitted a representation and I approached your lordship's court, my lord, which in the year 2009. Now, my lord, the court disposed of the petition, directing the undersecretary to consider. My lord, they maintained angelic silence with a conscious choice, my lord. I did not receive anything, my lord. Thereafter, my lord, after the solemn order was communicated, the Ministry of Home Affairs, my lord, page 77 to 104, my lord. My lord, if your lordship, my lord, kindly takes pen. My lord, that was in 6th August 2014. And it says it's issued a certain guidelines. It starts from 77 to 104. 77, 104, dated August 6, 2014. The relevant part is 99. Sorry, 92. I'm sorry, 92.
The scheme.
Yes, I will show guideline. Guideline, Millard. Millard, it's 6.1 income has been a cause of great confusion amongst the bankers, and therefore the following is clarified. Millard got it? 91, bottom 6.1.1.
Yes.
The source of income has been the cause of great concern amongst the bankers, and therefore the following is clarified. Now, Millard, kindly comes to Millard, the next page. The banks must ensure ensure that a dependent pension is not sanctioned to a spouse or a daughter of a freedom fighter. The spouse, daughter is already central or state government, central, PSU, state or local body. I am not coming within that. Am I clear, Millard? When the spouse/daughter is working in the private sector or having active of job activity. So, because my salary was 1,570 at the bottom. And comes to spouse daughter should not be receiving salary on account of his or service. Number the spouse daughter is already central I do come within this also. I said it's not all and clarification that has been afterwards. Then the explanation 393. May I take Margaret's contribution, please 93. This is because she is lawful a job and her position is rightly restored by the
Where from here?
She is lawful job or her position is rightly restored by the she gets a job. However, in future, in some stage, she is not entitled. I pointed out and I did so this also squarely applies to me and it does not so far as right to get entitled or continuous attention. Subsequently, the state government and the state government also Miller, page Miller, 1, 3, 1, 3. 113 Miller.
Yes. Yes.
Section 113 instruction some follow instructions undertaking that kindly comes to undertaking page 111 page 111
111 is the format.
yes that is undertaking.
Where is her undertaking submitted with?
No undertaking was not for me this is undertaking
Sir, she has,
no
in the with the application she has not given the undertaking.
no Millard because after the direction was made by your lordship's court Millard, I did not receive any order, but the afterwards, Millard 14, 17, the communication that has been made, I got this guideline, which Millard is affirmed by a 1113, 114 Millard, that this undertaking I have to submit. I am not working. I, such and such daughter of freedom fighter petitioner, such and such, do certify that I am not employed in central government, state or PLC local body. I
So what has happened to your application?
Millard,
After the order of this court?
no, nothing.
Where is your application?
My representation, Millard, past 2007, Millard, that is page 55, 56. Thereafter, the order passed by your lordship's court.
Correct.
Then Millard, then 2010 Millard, then order communication was made, 2010 Millard, 5th April, page 62 of your lordship's brief. Then 2014, 2015, 2016 Millard, these are the series of guidelines Millard, which Millard clarified the position and Millard it eradicated Millard all confusions Millard. whatever that was existed or presumed to be existed.
What is the page 175?
175. It is after filing of.
After filing this,
173?
once they communicated, Millard, 173. Forwarding letter and 175. A letter has been raised by such and such file Khara disbursement and the case pertains to the policy is being forwarded to your office for further necessary action.
It was sent to the undersecretary.
It was sent to the undersecretary.
Fund of Justice.
Yes.
Millard, may I take my letters kindly?
That was done. Lordship by 857. Directed past that we are not followed.
57?
61.
61 is the order.
Yes, 2009. Within a period of 8 weeks from the date of service of authentication of this order. Yes, 61.
Yes, circumstances.
Correct. No, that's what it's not say. It's content.
I find in representation, the could not support and find or not comparing the order.
No, but kindly come to the 173. 173 and 176, 175. 173 and 175. Yes. So now the matter is sent to the Director General of Audit Office has sent the matter to the Under Secretary. Correct. Let consider it. Correct. The authority will decide that you are appearing for.
Report number 6, my Director General of Audit Central Board.
Correct. This is your letter. Yes, Mr. Sinha. If they will give, then you will release. I am not deciding. The court is not deciding. Only I will see the earlier direction is there. They filed an application, and then the office of the account pay and account office already. Yes.
Yes, Lordship. This is my last representation.
What do you want?
Not let that be disposed because there is no order in black and white.
Correct. Let them decide. Let the final order come. Either allow your reject. Then the petitioner has filed the presented application. Saying for the direction upon the respondent authority, particularly the respondent number 3, to restore the Swatantra Sainik Samman family pension to the petitioner being the unmarried daughter as per the provisions of the scheme and other circular thereto. A scheme and the circular issued by the Government of India from time to time. The father of the petitioner was the freedom fighter and was granted and was getting freedom fighters pension. The father of the petitioner died on 10th of June 1989. After the death of the father of the petitioner, the family pension was allowed in the favor of the mother of the petitioner. The mother of the petitioner died on 29th of December 2019. Yes. You give the name.
Lordship, this is the list of dates I could provide.
क्या बोले father of the mother of the petitioner died on 29th of December 1995. 1995. 1995. After the death of the mother, the freedom fighter pension was granted in the to the petitioner. In the meantime, on 1st of November 1999, the petitioner joined in the state of West Bengal as assistant teacher. After getting the job in the government of West Bengal as assistant teacher, the the freedom fighters pension granted to the petitioner was stopped. The petitioner retired from the service.
It has not been stopped, my lord. I did not take that, my lord.
अच्छा क्या बोल रहा? On 1st November 1999, petitioner was has joined as assistant teacher in the state of West Bengal, and after joining the service in the government of West Bengal, the petitioner has not taken the benefit of the freedom fighters pension. Freedom fighter pension. Full stop. On 30th June 2007, the petitioner retired from the service without any pensionary benefit, as she was not qualified for the pensionary benefit. After the retirement of service, the petitioner is only getting rupees 14,517 per
Not
at the time of retirement, the petitioner has got only 14,570 rupees, and the petitioner is not getting any family pension, and the petition family pension from the government of West Bengal, as she retired from the post of assistant teacher, as she has not qualified the service for getting family pension. According, the petitioner has made a request to the authority for release of the freedom fighter pension. The authorities failed to consider the request of the petitioner, and according, the petitioner has filed a writ application before this court, being WP 6420 within bracket W of 2009. By an order dated 10th of September 2009, this court disposed of the said writ application by directing the respondent authorities to consider the representation of the petitioner for dependents pension. And it was also clarified that in the event the respondent authority was of the opinion the petitioner is not entitled to pension, due reason in support of the such opinion should be furnished to the petitioner within a period of 8 weeks from the date of service of an authenticated copy of the order. The order was duly communicated to the authorities, but the authorities failed to neither granted the freedom fighter pension nor rejected the request of the petitioner. The petitioner continued making some representation to the authorities, but the authorities failed to consider the request of the petitioner. Only after receipt of the legal notice of the petitioner, the office of the pay and account office within bracket pension and MIS, Ministry of Home Affairs within bracket Government of India, by a letter dated 29th April 2026, requested the Under Secretary FER Division 2nd Floor Ministry of Home Affairs for consideration of the request of the petitioner and for taking appropriate steps. Full stop. Consider the grievance and the full stop. This court find that only the grievance of the petitioner before this court in the present writ application is that in spite of the direction passed by this court in court on 10th of September 2009 and several representation made by the petitioner, the authorities have not considered the request of the petitioner for grant of family freedom fighters pension. Considering the above, this court find that no purpose should be served by keeping the revival of the considering the above, this court find that no purpose should be served by keeping the writ petition pending. According, writ petition disposed of by directing the respondent number respondent number 3 or any other respondent number 3 to consider the representation of the petitioner by taking into consideration of the order passed by this court dated 10th of September 2009 and to pass appropriate order within a period of 8 weeks from the date of this.
Lordship can allow me, Lord. Taking into considering the subsequent guidelines which have been
and the schemes and the guideline circulars issued by the government of India from time to time, and to pass the reason in speaking order within a period of 8 weeks from the date of receipt of this order. Full stop. It is made clear that this court has not gone into the merit, and all the issues kept open for to decide by the competent authority at the time of taking decision by the authority for revival of the freedom fighter pension in favor of the petitioner as per the request made by the petitioner. Disposed of.
Affidavit service, keep it. The affidavit service file, keep it.
Next.
Lord, I beg to appear for Lord the Child Welfare Committee. Lord, the issue seems to be very sensitive. May I beseech your lordships to hear us in camera? Is it possible so that Lord, the issue is very sensitive, Lord. I want to address your lordships on this. If my Lord allows us to address your lordships in camera, Lord, concerning the life of a child. So Lord,
Yes,
that would
in
be.
camera, and in camera, please go out.
There's no holiday on 16th. Keeps it on 16th. I want, instead of 15th, keeps it on 16th. 17 আমি নেই, 17 আমি নেই, 16th. 15 জায়গায় 16 লিখে নিয়েছো তো? But I'm grateful to this.
Well, that matter, this matter, well, already our name is featured in the merit list. And that matter went up to the Supreme Court. Supreme Court upheld the single bench order. Well, thereafter, after filing the contempt application, our name is featured. Well, then it's a long pending matter.
The fixed matter. Huh? The fixed matter, you could have been make arrangement to that. Short pass for what time? 10 minutes. 10 minutes, my other fixed matter will be there. Paso. Next.
Malad, this is my application, Malad. Malad, this is a writ petition, my lord. May I kindly first place the facts, how they are, my lord.
What is the matter?
My lord, there is a backdrop to it. The
affidavit in opposition, my lord.
The petitioner herein, my lord, this is my affidavit in reply, which has already been exchanged between the parties. Lordship, I will be very brief. Lordship, here what has happened, the petitioner herein, they import veterinary syringe from other countries. They have been in this business of import of veterinary syringe and distribution for over last 20 years. Now, my lord is aware that all these medicines or medicinal equipments are guided by the Drugs and Cosmetics Act of 1940. All this while, they have never asked me, or there was never a requirement for furnishing a license or a certificate, which they call the MD14 certification or license for import of veterinary syringe. In the year 2023, when I make one consignment of import from the country Israel, they suddenly hold my goods in the airport, and they this is done by CDSCO, which is Central Drug Standard Control Organization. Lordship, may kindly see there are two bodies here who operates at every ports as well as airport. That is, one is the customs authority. So first there has to be a custom clearance, and if there are certain regulatory guidelines, that has to be sent to that particular regulator. In this case, it is CDSCO, which is Central Drug Standard Control Organization. Now, interestingly, what has happened, my lord? They say that unless you secure a MD14 license, I will not allow you to take these goods from the airport. To which I have to carry on my business, to which what I do, I immediately apply. Without knowing into the things whether it is at all required or not. Because they say, given by the previous discussions which we had, which is all documented in the writ petition, I will show those pages subsequently. I apply for it. Now they say that this application can only be processed after you have filed all the documents. Now, some of the documents which they require are not even there. Now, how they are not there, my lord, may I now kindly, from their affidavit in opposition, I will show that the category in which this particular syringe falls, it has not been notified. The Act clearly indicates that unless it is specifically notified, you cannot ask for a clearance or a certification or a license for this. Now, my lord, would appreciate that any syringe which is administered on a human is always a single disposable syringe. During the period of COVID, we had...
What is your your prayer here?
My lord, my initial prayer was that please issue me the MD14 license. Because I was not aware as to what are the
No,
requirements for it.
as per your prayer, what your prayer? Concerned authority once issue the petition of one MD14 license.
Yes,
Who will give the MD14 license?
that is CDSCO. They will
Who is
issue.
appearing with CDSCO?
My learned friend is appearing
Yes.
for that.
So what is the procedure for giving the license?
Milord, MD14 is required, Milord. This is fall under the drugs, Milord. If your lordship kindly have a look at opposition, Milord, Milord, it has been hard. Milord, may place the interim order first, Milord, that is passed on 14th 2025. Have a look, Milord. 14th May 2025. Matter was hard, Milord. Partly hard. However, 14th May 2025, Milord.
Before exchange of affidavits.
Yes, Milord.
Yes.
Yes, Milord. Milord.
Yes.
Learned advocate representing the petitioner would, however, submit that the veterinary syringe in short the goods imported by the petitioner in August 2023 does not constitute a drug within the meaning of section 3B4 of the Drugs and Cosmetics Act 1940, hereinafter referred to as the said Act, and having regard thereto, the respondents ought not to have insisted upon the petitioner to produce a license meant for importing medical device in form MD14. According to him, having regard to the provisions contained in section 3B4 of the said Act, for a device to be constituted as a drug, a specific notification of the government is required to be published after consultation with the board. The same has not been done in this case. Having regard thereto, let this matter be listed on 21st May 2025 under the heading specially fixed matter. And Milord,
Correct.
Milord, last part is the very vital. The assistant drug controller, being the respondent number 4, herein is directed to file a report in the form of affidavit indicating that the goods imported by the petitioner required license in the form of MD14. All particulars inter alia, including the classification of the goods imported by the petitioner, must be disclosed in the affidavit. The notification as referred to in section 3B4 of the said Act so as to treat the said good as drugs within the meaning of the said Act should also be disclosed. Now, my lord, kindly come to my affidavit, page 27. Milord, this is the page 27, Milord.
Yes.
This is the requirement MD14, Milord. From number MD14, these documents should be given, Milord.
MD14.
MD14. This is called MD14.
Application form MD14.
MD14.
Yes.
This he has to comply because the thing is fallen within the category of drugs, Milord. Now, my lord,
Now, what you want to say from the page 27?
so remember this has to be complied with, Milord. These documents has to be sent because this syringe is fallen under the definition of drugs that I'll show you, lordship, page 51 of this affidavit in opposition.
51.
Yes, Milord. That is the definition, Milord.
Yes.
Yes, may I please? Milord, may I please see the book, Milord? 3B4. It has happened.
Yeah, you have disclosed 51 is there.
Yes, yes. May I read, Milord? Thing is this, Milord. Such devices mentioned for internal or external use in the diagnosis, treatment, mitigation or preventing of disease or disclosed in human beings or animal. This is very vital. Or animal, as may be specified for time to time by the central government by notification in the official gazette.
No, what is this? See, section 3 is the definition.
3B4. Yes, Milord.
3 is the definition.
Yes,
What is the definition?
Drugs definition, Milord.
And unless and until the subject countries Ayurveda, Siddha, Sanskrit, board means board, cosmetic, drug. Achha, 4B.
Yes,
4B4.
Yes, Milord.
What is the definition?
Definition of drugs, Milord.
Drugs.
Drug. So it is fallen within the ambit of
Devices
drugs.
intended for internal or external use in the diagnosis, treatment, mitigating or provisions of the disease disorder in human being or animal, as the may be specified from time to time the central government.
There is a notification also, my lord, to that effect. My lord, next page, kindly come to page, my lord, 53, my lord, that is the notification.
Yes.
May I read, my lord? In pursuant to subclause 4 of clause 5 of section 3 of the Drugs and Cosmetics Act 1940, 23 of 1940, the central government, after consulting with the Drugs Technical Advisory Board, hereby specifies the following devices intended for using drugs with effect from the first day of April 2020, namely, including an instrument, apparatus, appliance, implant, material, or other articles, whether used also or in combination, including a software or an accessory intended by its manufacturer to be used specially for human does not achieve the primary intended action in or human body or animals by any pharmacological or immunological or metabolic means, but which may assist in its intended function by such means for one or more of the specific purpose. 1. Diagnostics, prevention, monitoring, treatment, or alleviating of any disease or disorder. Here, their product is for prevention for animals. Poultry feeds, their injection, they want to bring the injection. That is within that drugs, my lord. Thereafter, my lord, the classification. As per interim order, I filed the affidavits. All the requirements. Page 54, my lord.
Yes.
Classification of medical device in vitro diagnostic medical device under the provision of the Medical Device Rule 2017. Safety, quality, performance, and medical devices are regulated under the provision of the Drugs and Cosmetics Act 1940 and rules made thereunder for the regulation of the medical devices for their with respect to the import, manufacture, clinical investigation, sale and distribution. The central government, after consultation with the Drug Technical Advisory Board, has notified Medical Devices Rule 2017 by GSR 78 dated 31st January 2017, which actually commenced from 1st January 2018. Now the basic of classification, my lord. In this connection, in exercise of the power conferred under section sub-rule 3 of Rule 4 of Medical Device Rule 2017, the undersigned is hereby classify the medical device and in vitro diagnostic medical device Appendix 1 based on the intended use of the device, risks associated with the device, and other parameters specified in the first schedule. List of the medical device and in vitro diagnostics medical device placed as annexed 1 subject to the following. General intended use given against each of the device is for guidance to the applicants intent to furnish application of import or manufacturing of medical devices under the provision of Medical Device Rule 2017. However, a device may have specific intent, use, or specific by its manufacturer. The component and associated to a medical device or companion in vitro diagnostic medical device has been classified separately. 3. It is also recognized that some of the medical device or in vitro diagnostics medical devices may have dual use. They may be classified accordingly. This list is dynamic and is subject to revision from time to time under the provision of the medical device rules. Thereafter, my lord, kindly have a look.
Where is this?
Page 82, my lord.
Page
82, my lord. My lord, item number 191, serial number 191, my lord.
Disposal hydrim syringe.
Yes, my lord. Disposable hydromic syringe, traditional single-use syringe without features, sterile hypodermic syringe for single use. Class B in the body. These they have bring the product, imported the product of the same category, my lord. Therefore, MD14, they should have complied the MD14, my lord. If they comply the MD14, we have no objection to issue. But he has to comply the MD14, my lord.
Yes. So how they can how
They have
can
not complied, my lord.
how they can comply with?
Sending all those documents at page, my lord, what I have at page 27, my lord. They should have sent, my lord.
Who will provide that?
My lord, they will provide that. Importer will provide that, my lord. Page 27, my lord.
Yes. A regulatory certificate. No. What is the checklist? What is the 27?
We are telling the formalities, my lord. What documents he has to provide after importing. This is the
checklist for the importer.
Yes, my lord.
Where from you got this?
Yes, well, he has to give all these documents.
Where from this got? How this page 27 is the authenticated?
My lord, I have filed the affidavit, my lord.
That's why from where you got this? Where this checklist is mentioned, which law, which rules or which regulation or which act?
Checklist, my lord.
From which act or which circular, which notification this checklist has been?
My lord, this is the Drugs and Cosmetics Act 1940, my lord. I have placed, my lord, the section is drugs, and if this is drugs, it is for.
That's correct. What you are satisfied, it's a drugs, it's coming under the drugs, whatever it is. Yes. Now MD14, you are relying upon page 27.
Yes, my lord. Yes.
Correct.
Yes, my lord.
Page 27 you are relying upon.
Yes, my lord.
Page 27 is the checklist.
Yes, my
So
lord.
this checklist, how you got this checklist? Where from you got this checklist?
Well, from the department, my lord.
Well, that's why who has authenticated this?
Me.
You should, any form, any format, anything is to be in accordance with the rules or an act.
Yes.
6.
My lord, paragraph 6, my lord. CDSCO, I think, my lord.
Paragraph
6, my lord.
6.
CDSCO, my lord.
Role of CDSO and State of Control, Central Organization headed by the Drugs Control of India, discharge the function allocated to central government, is Office of the Director attached to the Ministry. That's correct. How this? What is the annexer? 27. What is the annexer?
Lord,
what is the annexer? Annexer R1.
Yes, annexure. May, please, my lord. May.
27 is a continuation of the R1.
May.
Part 2.
R2.
Where
is R2? Where
R2 starts from page 19.
Page
19, my lord.
Of their
19.
opposition.
How you are dealt with? Where is the R2 dealt with in your affidavit?
Well, 19 is for, my lord.
No.
Manufacture.
Where you dealt with the R2 in your affidavit in opposition?
R2 page 19, my lord.
That's on the documents checklist form D17 for the said product required in order to obtain the license.
It is for manufacturer.
For manufacturing.
For,
the MD14 for importer.
For importer, my lord.
For the said. Okay. Yes.
My lord. My lord, I'm so grateful to my learned senior friend because half of the case which he is running really helps me. My lord, may kindly now first take up page, I will straight away start from his opposition, page 54.
Page
54.
Yes.
My lord, prior to that, I would just conceptualize. The Drugs and the Cosmetics Act gives a wider umbrella under which everything has to be classified. The Act specially leaves a provision that every such categorization has to be notified. And that is why the medical device rules comes into play. These rules, my lord has seen from page 54. I will not read out the entire notice all over again. I would be stressing on serial number 4. It says that this list is dynamic and subject to revision from time to time. That means they will keep changing upon the policies of the government. If certain new devices has to be included because of progress in technology, that will come into force. If certain things have to be upscaled, there are scalings A, B, C, D. Some may be upscale, some may be downscale, depending upon the situation. Now, my lord, going back to what my learned senior friend had placed, page 82. My lord, may kindly see this. My lord, may kindly open page 82. Prior to that, my lord, I will take this indulgence of showing this court how the syringe is different from that of an animal. This which I am handing over, my lord, I can also show a sample to my learned senior friend. I'm just handing over with the leave of the court. My lord, may kindly see. This is a disposable syringe. Now, these are very important. A human beings, even in a scale of mass vaccination, they are never given a syringe which is used multiple times. These are single-use disposable. I completely agree with my learned senior friend. Now, my lord, I am handing over the syringe which is used for animals.
No, question is not that.
My lord,
Question is that whether the syringe is coming under the purview of the drugs or not. Correct. If the syringe is coming under the purview of the drugs under the rules and the acts, then you have to follow the MD14 for getting the
I bow
license.
down. I bow down, lordship. My
So,
only
as per your case, you have brought from wherever from here, you have brought this syringe.
Yes.
The authorities have got hold of this syringe and you fail to produce the document.
Yes.
Only you're telling that it is you have brought from there, you have a bill, whatever it is, but as per the law, you are not having the license with regard to that. Now they are telling that it is the medical device which is coming under the purview of the drugs, so license is required.
My lord, there is
So
a
what
slight
what is the submission here?
there is a slight change. Yes. I completely agree. I, being an entity operating in a country in India, and I originate from India, I have to be bound by the laws of the country, whether I like it or not. My lord, according to them, what my endeavor is to show that this particular syringe is not even classified under the MD17 rules.
Why?
If it, my lord, may kindly see, because my lord has to see this in order to understand how it operates. I'm not running away. Even they did not clarify to my RTI application. My lord, may kindly see, this is in the shape of a syringe gun. What happens is there are pipes to it. This is basically used in a poultry farm. In a poultry farm, my lord, it knows that there are chicks which needs to be vaccinated. Those chicks are in thousands. How are they done? That is important. The chicks are held in one hand, and from the other hand, this syringe is held, and they are injected, and then they are thrown in another box, and another chick is taken up. This is without continuous sterilization. My lord, I am stressing on this word, without continuous sterilization.
So in that case,
kindly visualize the.
So in that case, so it has to be sent to the competent authority whether this is the medical device under the
Lord, I bow down, my lord. At page 82, what does it say? My lord, page 82, serial number 191, which my learned friend was placing, it says disposable hypodermic. What is hypodermic? Hypodermic is basically a hollow cylinder.
Correct.
All syringes are hypodermic syringe.
Correct.
Disposable hypodermic syringe, traditional single use. This is not a single use, my lord.
What then you have brought this or you have brought this?
I have brought that because
Which
that
one?
is for veterinary purposes, only to be used in poultry farms, not on humans. There is a clear distinction. The act lays that everything falls under the wider umbrella. But when it has to be specifically notified, let my learned friend show that this is for multiple use, I have to bow down. Because, my lord, the other thing, what they are asking for, and which I have also denied in my reply, my lord, may kindly take up my reply for a second.
Who has filed this affidavit? This affidavit filed by whom?
Yes, my lord.
Assistant Drug Controller.
And my
Assistant Drug Controller.
yes, my lord.
What is your final observation? What is the final observation? Have you examined this instrument?
Milord, they have specific instruction. It is falling within the definition of drugs because
No,
this.
whether you have examined this instrument
Yes, Milord.
before giving this report, have you examined this? Whether this is a disposal syringe or this is something else? Have you examined this?
Then I have to take instruction on that point because, Milord.
Now it's okay. See, there are several things are there. Now this is the disposal, correct? And this is, I don't know what it is called.
My lord, it is called a Thamas, the model number is a Thama veterinary multiple use syringe.
So that's why what I propose to do, the drugs controller is there in the West Bengal.
Yes.
Drugs control is there. And what are the other authorities? Let they examine this instrument.
As your lordship,
coming under the purview of that.
As your lordship, please, as your lordship. Kindly
clarify because
Milord,
I have been
okay.
Since I have been, my goods are stuck in the airport for more than 2 years now. My lord,
2 years.
Yes, because this was imported in the year 2023. Thereafter, they said that you apply for MD14 license. This the importers, my lord, who have been doing business for the last 15-16 years. Now I will show there are way more deeper things because if it is imported, then you have to get an MD14 or an MD17 license. If you are a manufacturer here, which I will show, they are not insisting. How can there be two different types of drug standards in a country? If a medicine, if it is.
So what is your case? Your case is whether it is coming under the MD17 or MD14 or not.
From their documents, I have been able to show it is not because these are not single-use syringes for animals. My lord, may kindly see also, only for my satisfaction, my lord, may kindly turn to page 63 of my writ petition. Since there was a confusion, I also made a RTI application.
63 of your writ petition?
Yes. My lord, I had made a specific RTI application, my lord, where I had requested them, please provide.
Yes.
Let us see this. Please provide information if the syringe used for veterinary purposes classified under a medical instrument. Please provide classification of medical instrument used for human use consumption is the same to that of the medical instrument used for veterinary purposes. And my lord, may kindly see D. Please provide information if any permission has been granted to any domestic manufacturer because there is even a specific allegation on my which I have raised.
What is the reply? What is the reply?
My lord, may kindly see this is the reply to Judge Sahib Kedin. This reply was perhaps not annexed there. My lord, may kindly see their reply. Absolutely evasive, my lord. May I kindly read? Please refer to your RTI application dated so received by this office. In this regard, as per available records with this office, the requisite reply is under. In India, medical devices are regulated under the Drugs and Cosmetics Act. I don't deny that. And medical device rules. This is important, madam. If my device does not fall under medical device rule 2017, you cannot ask for a license.
So that's why that has to be. Oh, the court cannot.
No, they will. They will.
That's what they have. That's what I'm telling. Let the drugs controller examine the. Let the drugs controller take the sample from the. This sample from where it is.
As your lordship, please.
Where it is there.
There is a notification.
No, not handing over. What is the? This is the. Where is it? It is lying now.
This is with the airports authority.
Airport authority. So it is a Caesar is the custom authority. Let in presence of the petitioner on the official of the drug control authority that the sample be taken, 2 sample or 1 packet may be taken, and the drug control authority examine this and whether it is coming under the MD14 or not. Let the report come.
I'm grateful.
And Milord, the notification is also for human and animals.
No, that's correct. That is no. Whether this is coming under the purview of the syringe.
Yes.
that is as provided under the 17 rule or not?
Yes, single use syringe.
Single use.
Yes.
So let them, you
My
take
lord.
the sample from the custom authorities in presence of the petitioner and your officer and what is drug controller general.
Yes, my
Who is
lord,
there?
this is at
Who is
at
there?
the-
Who is the competent authority here?
The competent authority would be petition respondent number 4. 3 is the Drug Controller General of India, my lord, who is the
That is
central,
the center.
and 4 is the Assistant Drug Controller, the one who has
The
appointed.
assistant is submitted this affidavit. I
Yes,
don't
yes,
want
yes.
that. He should. I don't want that.
That's 3 and 4. My lord, I'm okay with that because, my lord,
I'm
I
okay
will be
with that.
I'll be very candid, my lord. They cannot walk beyond the parameters of the statute.
There is a notification also.
No,
my lord.
there is a
Will
notification.
Animal and man, human and animal. This
Oh, that you're satisfied.
Lord-
But with regard to this instrument coming in
specific
that
for this
single use,
instrument.
yeah,
As your lordship, please.
Multiple use, my lord, because
because we are not the expert.
No,
Let the expert
My
report.
lord, at
No,
the-
I am also not
my lord,
expert.
at the
Let
verge of-
them decide. Will not kindly
Lord, at
direct
the
them to
verge
decide.
of repetition, I will just draw inspiration. Like lordship, since 2020, we all have been vaccinated multiple times. There have been large scale global vaccination, but lordship, there has been not been a single case on humans that one syringe is being used twice. For animals, there are certain syringe which are used for mass vaccination.
Okay.
And notification 11 February 2020. Notification published.
Petitioner has filed the present date application praying for a direction upon the respondent authority to issue. Now you are praying for issuing the license.
My lord, that was initially because
So your prayer is that
I know that my
His
lord, but-
prayer is otherwise, my lord.
My lord,
His prayer is otherwise, my lord.
absolutely. Because
Lord-
lordship, now they are asking for documents, lordship, which I can't even produce
Lord-
because the manufacturer does not have those licenses. Because for making a single use
the petitioner in the month of August 2023, the petitioner has brought different type of veterinary products, which includes automatic double syringe, plastic tubes for syringe, piston, bridge for 2-to-1 needle with the said Israeli company, E full stop Nechmed Limited. Right, huh? Nechmed Limited. Full stop. The allegation, the case of the petitioner is that when the petitioner has brought the said materials, said goods, the custom authorities have written this.
Yes.
The custom authorities of the airport have retained the goods imported by the petitioner. The contention of the petitioner that the goods which the petitioner has imported does not constitute a drug within the meaning of 3B within bracket Roman small 4 of the Drugs and Cosmetic Act 1940. In terms of the order passed by this court dated 14th of May 2025, the assistant drug controller within bracket India, Central Drugs Standard Control Organization has submitted an affidavit disclosing certain documents, including the notification dated 11th of February 2020, wherein it provides that all devices, including an instrument, apparatus, appliance, implant, materials, or other articles, which whether used alone or in combination, including a software or an accessory, intended by its manufacturer to be used specifically for the human beings or animal which does not achieve the primary intended action in or on human body or animals by any pharmacological or immunological or metabolic means, but which may assist in its intended function by such means for one or more of the specified purposes. The said report, and in the said notification, it is also mentioned purposes. The said affidavit in the affidavit also discloses the notice dated 1st November 2012, wherein the list of the medical devices rule 2017 is enclosed, wherein serial number 191, the disposal hypodermic syringe, has been mentioned. As per the contention of the respondents, that the syringe which the petitioner has brought is coming under the purview of medical devices rules 2017. The petitioner has shown the devices which the petitioner has brought and was apprehended by the custom authority in the month of August 2023, and submit that the said device is not the syringe. It is only a piston.
No, it is, my lord. My submission is it is not a single use.
It is not a single use syringe. It is a plastic tube for syringe piston bridge.
Which is for use for multiple purposes.
It is not a single use syringe. It is a plastic tube for syringe piston, which is for multiple use, and as such it cannot
On
be
animals, my lord.
for animals, and as such it is not covered under the medical devices rules 2017.
I'm good.
Considering the submission made by the counsel for the respective parties, this court find that a report is required to be submitted by the respondent number 4, that is assistant drug 4 or 3.
My lord,
4 or
three,
5.
three, I think three would
3 is
be
the Drug Journal India.
yes.
4 is the Assistant Drug Controller India.
Who has already affirmed.
Yes. Respondent number 4, comma, the Assistant Drug Controller within bracket India, Government of India, Ministry of Health and Family Welfare, CDSO within bracket East Zone, comma, Office of Deputy Drug Controller within bracket India, Nizam Palace, MSO Building, 7th floor, shall take the sample of the goods from the custom authority in presence of the petitioner, and shall examine the same and to submit the report whether the goods which the petitioner has imported and have been apprehended by the custom authority is coming under the purview of medical rules 2017. Let the said rule and that the report be filed within 3 weeks. 4 weeks, what 4 weeks? 1 week.
In such a long time.
Within 3 weeks.
But instead of only respondent number 4, may it be also 5, because I see he is additional drug controller.
4 and 5 million. 4 and 5. 4 and 5. Huh?
My lord had indicated that it is with the customs authority at the Kolkata airport.
But customs authority made a party, my lord.
Custom authority. No.
Not required.
From the custom authority of Kolkata, the Netaji Subhash Chandra Bose Airport, Kolkata.
I'm grateful, my lord.
And to submit the report before this court in a sealed cover within a period of 4 weeks. 4 weeks. This is the matter on आज कितना तारीख है? No. The matter appear on 13th July 2026 under the same heading within 10 matters. Take this.
I'm grateful.
But I was at fault, my lord, because one matter was going on still.
So next day, come on the next day.
My lord, kindly do not keep it next week. I have spoken to my other side.
Next week, now I have not diary. That's what I'm telling. My diary is till September is full. Fixing date. If you want normal date, I can fix any date. No problem.
Kindly give any date according to laws.
लास्ट कभी कब है, फिक्सिंग कब हो सकता है? Eleventh August you will get. Or you want on the normal date, because normal date it will not be possible. Though the matter is fixed today at 12 noon as a specially fixed matter, but the matter could not be taken up for hearing due to preoccupied by the learned advocate for the respondent in some other matter. According cases adjourned, let the matter appear on 11th August at 12 noon as a specially fixed matter. Okay. Yes, next.
My lord, I am for the petition, my lord. My lord, for expeditious hearing, my lord, petitioner's family.
Tribunal is working. Tribunal is working.
Hardly working, my lord. My lord, the unfortunate part is all the members of the petitioner's family's name is there, father, mother, son, daughter, only the petitioner and his son's name is not there.
How many petitioners
My
are
lord,
there?
Two,
Yeah.
father and son.
2 appeals are there?
Yes, my lord, 2 appeals. I have annexed 2 appeals in prior, my lord, if your lordship kindly sees.
60 and 63.
Yes.
Recall. The grievance of the petitioner in the present date application is that the petitioner has preferred an appeal, and petitioners have preferred their respective appeal before the SIR appellate tribunal against the deletion of their name in the voter list, but the appeal is still pending and prayed for expeditious hearing of the said appeal by the SIR tribunal. Consider the submission made by the counsel for the petitioner. Petitioner writ petition disposed of by requesting the appellate tribunal and the SIR tribunal to dispose of the appeals preferred by the petitioners dated 7th April 2026 as expeditious as possible within a period of, preferably within a period of 3 months from the date of receipt of this order.
My lord, my service may be kept with
Service super na affidavit kept with.
and দিয়ে দিয়েছি এটা হ্যাঁ স্ক্যান কপি দিয়ে
Yes, next.
না না শুধু 60 মানে 61 I appear on behalf of the petitioner.
Yes.
This is in respect of, my lord, the extension of the recommendation of the school service commissions.
Huh?
The recommendation.
Why it has come? It is not the SIR matter.
SIR নয় তো এটা।
It is not the SIR matter. इसको उसमें मेन में डालो, कल रखो। कल tomorrow.
Yes, ma'am.
Tomorrow. Tomorrow.
Item number 23 is an SIR matter.
Yes, next.
62, my lord, I am appealing for the petitioner, my lord. Lord, with prayer, my lord, expeditious hearing, my lord. The
How many petitioners?
Only one, my lord. Serve upon all, my lord. Petitioner is the primary teacher, my lord. Name of all family members.
Same
are, my
order,
lord.
na? Only petitioner hoga. What is the appeal date? Where is the appeal?
My lord. Appeal on 7th April.
Normal order कर दो, वाला है ना? है नहीं है तुम्हारे पास? कर देगा ना?
My lord, 7th April, my lord.
7th April. Disposal. Yes, next. Preferably within a period.
My lord, 63 I appear for the petitioner. This is not relating to SIR matter. This is a interest matter. Payment already made, but interest
Not today. Not today. Next.
Every service kept with the date.
Next. 63.
Similar matter has been fixed on 16 July.
64 I am appearing for the petitioner, my lord. This is for the respondent. This is also not an SIR matter, my lord. But my lord, the subject matter is covered by one of your lordship's orders, which is annexed to the petition, my lord, the last annexure.
क्या हुआ? ये क्यों आया सब?
Didn't come on Wednesday. By May,
There are some other matters.
but since we have reached the matter, my lord, may it appear, my lord, on Wednesday, my lord, when the other matters are appearing under the heading urgent motion.
Matters are there, so it can
But
appear on Wednesday.
probably much time, my lord, it's covered by your lordship's order.
Which one, that one? Vehicle?
This is a termination of tank trucks, my lord. For PSO license and transfer of registration.
এটা করেন इसको ना Wednesday रख दो. Wednesday within 10 minutes.
Along with the other bunch, there are a few
Other matter, which matter?
We have already mentioned, your lordship directed those matters to appear on 8 July, my lord.
Let it be on 8.
Lordship.
8th, huh? Urgent motion within 10 minutes.
Grateful.
Yes, next.
But I'm a petitioner, but I appeal paper on 6th April, my lord. Our petitioner is not getting chance. He has got chance, my lord, for admission in MS in Jadavpur University, but without the voter card, he is not.
Where is the appeal?
6th April, my lord, appeal has been prepared.
Where is your appeal?
Appeal was, my lord, appeal was page 30 to 38.
No appeal.
Well, page 30.
Where is the appeal?
An offline prepared, but
The appeal number has to be there. For offline, they may approach the DM office
page 30, my lord.
and get
Huh?
the number.
Page 30 is the
That 30 is the physical appeal.
physical appeal.
So where is the number?
The number
Even
is
for physical appeal, they would endorse a number. They will have to obtain it from the DM's office. These
Yes.
matters will be adjourned for next week.
Yes, how it can be? Without the appeal number, how the can be?
but they can consider it, my lord.
Without number,
Lordship,
how?
Lord, I follow lordship, but my lord, the appeal number could not be collected. I'm saying that let them consider this application.
Track করতে পারবে
Arey, appeal, before the appeal authority, if the appeal is not there, you contact the DM office, get the number, come with the number, not today.
Lordship.
Not today. Next.
But six, this is also what appeal has been prepared as a P6, page 28. On 4th April, appeal is prepared. At the bottom, page 28.
Yes. Disposal, huh? Within 3 months. Republic within 3 months. Next.
Obliged, lordship. Not
67, my lord, I am appealing for the petitioner, my lord. Appeal preferred, my lord, page 27, my lord.
কোথায় পাবো ম্যাডাম
On, my lord,
কোথায় পাবো appeal number? আবার ডিএম যেতে হবে
1st of April 2026, page 27.
Yes. Disposal.
অনলাইন করতে
Next.
হবে এটা 68 is my petition, right?
At page 14 is my appeal, my lord, filed on 6th of April.
Disposal. Next.
Well, it's 69, page 14 is the appeal, my lord. Filed on 8th of April, my lord. Page 15 is the date.
Yes. Next.
Well, at 70, page 13 is the appeal, my lord. Filed on 8th of April, page 14 is the date.
Yes. Next.
সার্ভিস may be taken on record.
Next.
সার্ভিস দাদা সার্ভিস
71, my lord, I am appealing for the petitioner, my lord. My lord, here, my lord, some difficulty. The petitioner is the Panchayat Samiti member, my lord, is the public representative, my lord. My lord, I am praying for early date.
Where is your appeal?
My lord, appeal at, my lord, page 36, my lord.
Page?
36.
Yes.
36, my lord. Lords. I'm praying for some early date. The petitioner is the Panchayat Samiti member, my lord. Since, my lord, he is, my lord, some Anastha and all those things are going on, my lord, he is also in the
He's not
race.
been allowing.
No, my lord, appeal is pending, my lord.
So he's not been allowing to participate in the meeting.
No, my lord, there are some gossip and apprehensions, lordship knows, my lord, that practically.
Disposal. Yes, next.
My lord, I am for the petitioner, my lord. My lord, in that case, my urgency is passport, my passport application, my lord, hold, and my
Where is your application?
application is page 16, page 16, my lord, annexer P1, appeal dated 24/05 of 2026.
My lord, kindly mention my urgency and my appeal number.
26, yes, disposal. Next.
My lord, next time for the petitioner, my lord, page 14, my lord.
14,
Yes, my lord.
yes, disposal.
Grateful, my lord.
My lord, I'm for the petitioner, lordship. My appeal is at page 100, lordship. Appeal was filed on 7th of April 2026. I'm for it.
Page
Page 100, lordship.
Yes. Next.
Grateful, lordship.
Every service, my lord. My lord, appeal, page number 21. April, month of appeal.
21, where is the appeal?
Page 21, my lord.
Where is the number?
Manual.
Number, where is the number? You get a number from the office and come, not today. Next. 25, not today. Next.
এই নাম্বার নিতে গেলে ডিএমএ যেতে হবে। কত সপ্তাহ পড়েছিলেন?
76, my lord, I am appealing for the petitioner, my lord. Your lordship, kindly, my lord, this is the matter, my lord, different from the, my lord, SIR appeals, my lord. The name of the petitioner is still, my lord, appearing under, my lord, under adjudication, my lord. And the petitioner, my lord, approach before the authority, page 58, my lord. Thereafter, my lord, page 59 is very important, my lord. This is the, my lord, the letter with memo number sent by the AEO to the, my lord, district election officer, my lord, intimating, my lord, that these are the, my lord, number of persons whose name are still, my lord, appearing under adjudication, my lord. And, my lord, that, enclosing that letter, my lord, page 59, my lord. Enclosing that letter, the petitioner, my lord, submitted representation, my lord, page 61, my lord. And, my lord, the authorities are still sitting tight over the matter, my lord. In this matter, my lord, I am respectfully praying, my lord, for a report, my lord, from the DO, that whether, my lord, after submitting this representation, my lord, any step has been taken, my lord, whether the name of the petitioner is under, my lord, since it is appearing under adjudication, and the name of the petitioner's
What is
father.
your name?
My name is, my lord, Henara, my lord.
Huh?
Henara. Oh, my lord, in the,
so page 58, what is the page 58?
lordship. Page 58, my lord. Page 58 is the, my lord, the Henara, my lord, wife of Mukimuddin, in the, my lord, right
It
side.
is the ARO, appeal for restoration of my name.
Page 59, my lord.
Page 59 is?
Page 59 is the letter sent by the ARO to the DEO, my lord. Kindly, my lord, have a look, my lord. My lord, part number 1, where, my lord, others cases are also false under adjudication.
Where is your name?
My name, my lord, is the next page, my lord, page 60, my lord. Page
304.
304 is the, my lord, serial, my lord.
Henara Begum.
Henara Begum, my lord.
So I am disposing of the DO.
Your lordship.
My lord, if your lordship kindly, my lord, take the DO, my lord, for
That time
a report.
disposing of DO pass and not if he allowed, then allow. If it rejected,
Lordship.
In terms of page number 59 and 60?
60.
Yeah, your lordship. It may be
We got an order.
60, and my lord, considering page
The
61,
grievance
my
of the
lord.
petitioner is that the name of the petitioner was forwarded by the block development officer to the election officer on the ground that there are some discrepancies between the electors, full stop, and the same is pending for adjudication. The petitioner has made a request to the DEO. DEO is the party here.
My lord, DEO is the party, my
DEO
lord.
District Magistrate, Uttar Dinajpur, for consideration of the request of the petitioner for restoration of her name in the electoral roll, but the roll on 11th of May 2026. But in spite of receipt of the request of the petitioner, the DEO has not considered the request of the petition. The same is pending before the DEO. In view of the submission made by the counsel for the petitioner, the petition is disposed of by directing the DEO District Magistrate Uttar Dinajpur to consider, the respondent number 6 herein, to consider the representation submitted by the petitioner dated 11th May 2026, and to pass, after giving an opportunity of hearing to the petitioner, and to pass the written and speaking order within a period of 3 weeks from the date of receipt of this.
Extremely good. Milord, may I put, if in the light of Milord, the letter of the AEO Milord, page 59 Milord,
Recorded.
extremely grateful Milord.
Next.
Malad 77 malad and malad selling malad and my refusal of granting me passport on the ground malad kindly come to page 50. Page 50 annexure P11.
What? This
Malad,
is passport.
Malad passport initially passport application for passport was
What
made.
is your prayer?
My appeal is pending.
Correct.
Malad, in the prior to appeal, prior to adjudication, I have applied for passport, and in the meantime, my name has been deleted. I preferred an appeal that is pending at page 44 and
44 to that.
page 44. Appeal number is there. And Malad, in the meantime, I was called for interview. I went there, submitted all documents as required under the Passport Act. In spite of that, having other documents, they say that my name cannot be considered because my name is deleted. This is Malad, contrary to law.
Correct.
Because
No, if you want this writ petition is to be if you are for the appeal or with regard to the passport. Both cannot be in the writ petition.
because
How you can pray the two prayers in the one writ
my
petition?
prayer, your lordship kindly sees because of this. My passport has been already refused, and I have made passport authority the party.
That's why if you want the order with regard to the passport,
That your lordship for the time being direct the appellate authority, my lord, to consider, and in that event, my lord.
It's a usual order, your
disposal. Next.
Stand copy.
I am appearing on behalf of the petitioner, my lord. Appeal is annexed with my writ petition, page number 83. my lord.
Page
83.
Yes, disposal.
Next. May I request one thing? Because of that, my lord, a large number of persons, my lord, land registration is not possible due to deletion. Because of that, there is no such governmental order. But the fact is remains that, my lord, whenever they went to the registration office, they says your name is not in the voter list, so you can't register the land document. It will be kind of, my lord, at least 100 matters, my lord, in a week, my lord, at least 100 matters.
Yeah. Come.
At least 100 matters, my lord. At least
First you go, if it is not disposal, then come. Yes.
I'm for the petitioner, my lord.
Where is the appeal?
My lord, page 28.
Yes, disposal.
My lord, I am for the petitioner.
Page
16, my lord.
Yes. Next.
My lord, I am for the petitioner, my lord. My lord, in that case, my lord, something different actually. Petitioner and petitioner sons are live outside India, and they are all others passport. My lord, hold, my lord. My lord,
What do you want?
my lord, I want expeditious, but kindly time bound, my lord.
Disposal. Yes, next.
Yes, my lord.
My name was deleted owing to
Where is your appeal?
the appeal number at page number 19.
9. Page 9, paragraph 30.
Paragraph 30.
There's no appeal.
Or annexure 88.
Annexure?
P8.
Page. Yes, disposal.
83, my lord, I am appearing for the petitioner, my lord. Page 29 is the appeal, my lord. Referred on 8th of April, my lord. Only, my lord, I am praying for leave to refer, my lord, page 41. The petitioner is senior citizen, my lord, suffering from various ailments within a span of every 3 days, going through, my lord, kidney dialysis, my lord. So, my lord, is worst position. I am putting for only some early date, my lord.
I have given, preferably I have given. Record इसमें ना एक out कर दो. The appellate item number 83. The petitioner, the counsel for the petition submitted the appeal before the appellate authority on 8/4/2026, but the same is pending. He further submitted the petition is a senior citizen and is suffering from various ailments, and due to the deletion of the name of the petition in the voter list, he is suffering very badly. He is facing difficulties. The counsel for the petition prays for disposal of the appeal as early as possible. In view of the submission made by the counsel for the petitioner, the appellate authority is requested to dispose of the appeal of the petitioner, being appeal number APS 2508G 08042650308 dated 8th April 2026 as early as prepared within a period of 1 month from the date of receipt of this. Within 30.
Grateful. I appeal for the petitioner. On the page 23 is the appeal.
20?
Page 23.
23.
Yes, my lord.
Yes, disposal. Where is the appeal? Where is the appeal? Disposal. Next.
My lord, 36 at page 36.
Yes, disposal.
Okay, affidavit of service.
Next.
My lord, 87, my lord, page 57 is the appeal, my lord, only one. This candidate, my lord, requires some urgency. My lord, she participated in the recruitment process July from 20th of July.
What recruitment process?
My lord, for primary teacher, my lord, difference is his original name is Bonik and now it has been from Dotto. This is the difference. My lord, EWS certificate she could not obtain because of this. My lord, can it be within 15 days as a special case?
Without giving the month, I'll try.
Disposal as early as possible. Month लिखो.
How 24?
As early as possible, huh? Within 3 months month लिखो.
My lord, my affidavit of service in 87.
80? 88. Who is appearing? Disposal.
Well, item number 23 is also an SIR matter, my lord.
Yes.
Item number 23. Page 46 is my appeal.
Item number 23.
Yes, my lord. Page 46 is my appeal.
23 disposal.
Grateful, my lord.
But may I mention that item number 7, 8, and 9, but we were not given any notice that the matter was mentioned before your lordship. Today, my lord, we find
Withdrawal.
For withdrawal, my lord, I was for the yes, but the only thing is, my lord, if it is only simplicity
Withdrawal, only withdrawal.
But I think, my lord, they have put in something that the state government consent is not necessary.
I have only recorded as per the instruction, withdrawal, dismiss as withdrawn, nothing else. Neither leave nor anything.
So if that is so, my lord, I have no objection because at least
Only recorded as per the submission and the written instruction, dismiss as withdrawn.
But because I was apprehensive, my lord, there was a declaration of there was
No, nothing.
Lord, let our appearance be.
कौन लिया उसको 7 8 5 6 7 8
No, 7, 8, 9.
7 8 9 में ना कौन सौरभ लिया लगता है ना उसका नाम give the name, give the name and item number
7, 8.
हाँ हाँ
I think, my lord, I came to know, my lord, I don't know whether that is correct or not. But the file is not.
18 no 18 is there. What do you want?
Let the matter be fixed on tomorrow.
Yeah, it will be tomorrow. It will be there because the matter is not called. It will be there tomorrow.
Then the matter will not be called.
that was not with me in that item 16. If you lordship directs your lordship officer to give me a photocopy, my lord,
I have passed an order to
supply. But I'm grateful to your lordship, my lord. But if I get that, my lord, I can come ready.
you can get tomorrow.
My lord, I'll come back, my lord, I'll come and take it.
89.
My lord, I appear for the petitioner. This is a very interesting case for me, at least because I am a victim of something which is akin to what is being
opinion.
Yes, this media trial, before somebody is, my lord, actually, my lord, found to be guilty, is the subject matter of this writ petition. Now, my lord, the petitioner before my lord, is a housewife, homemaker. Her husband seems to be a very important personality over here. And, my lord, she has to bear the brunt of the society, including the journalists, in respect of certain activities with which she is not concerned. No, it's something like being, of course, as husband and wife, we have to share many things, but not, my lord, this so-called disrepute. So, this is the subject matter of challenge, my lord. My lord, at the interim stage, my lord, a coordinate bench, my lord, was pleased to go through the matter, my lord, in great details, my lord, and then, my lord, an order was passed, an interim order was passed, primarily to guide, my lord, the media as to what is their role during investigation. How far or how much of the information
They
can be disseminated in respect of an ongoing investigation. Now, if your lordship may kindly have a look to, my lord,
Who is for the state?
But there are various respondents.
All are appearing.
My lord, I am appearing on behalf of enforcement.
Enforcement
Directorate.
Directorate.
Number 19.
Can it be taken today?
But I am more or less
It is
ready.
completed.
Yes, sir, please are completed.
But other who is for the state?
State.
Rajarshi Basu.
But at
And-
that point of time,
Basu.
April.
April.
Rajoshi Basu and KM Hussain.
Yes.
I don't think that they are.
Still in there.
I don't think so. Subject to correction.
And Mr. Trivedi is already
Mr.
there.
Trivedi is there.
Or enforcement director.
Yes.
Is for
Mr.
the enforcement.
Bhattacharya is there. Union of India.
Council of India. What?
Lordship, I am appearing for the Union of India, Press Council of India, sorry.
Let's Council of India. 6 and 7, Mr. Menon. So, if the state is not there, how it can be?
But I can come back on some other day as per the.
But he notified to the state.
Very well. But the interim order is limited. If your lordship may.
Today?
No, it's still fixed.
6 July.
Yes.
Okay, I am extending. What is the interim order?
But it gives a lot of directions.
Okay.
Kindly take me, Lord. Yes. 74, 70.
Order dated?
The 17th October order, if your lordship may kindly take page 35 of the order.
17th October 25.
2023.
It's still going on.
Yes, because
Paragraph?
Because para 70 at page 35.
Yes.
Regarding investigating agencies before filing of charge sheet,
Shall
the
not-
investigating agency, in the present case ED, shall not disclose to the public or the media the circumstances, reasons and or details of the interrogation, raids and search of any person, be he, she an accused.
Whether the investigation completed?
No, I'm told it's ongoing.
No, charge sheet not filed. A final report not filed.
Milord, charge sheet file, but further investigation is going on.
Further investigation. Let us see. None appears on behalf of the state. This court finds that the presence of the state is required at the time of hearing of the present application. According case adjourned. Let the matter appear on 1st September at 2 p.m. as a specially fixed matter. Interim order is extended till the next date of hearing or until further order, whichever is earlier. The learned advocate on record of the petition is directed to inform the next date of hearing to the learned counsel appearing for in next date of hearing to the office of the learned government pleader. The government pleader is requested to make necessary arrangement to represent the state before this court in the instant matter on the next date fixed. Let the matter appear on 1st September at 2 p.m.
But may I request, Miller, the interim order may be extended 1 or 2 days more.
1st September, hai na?
Yes. Maybe for 2nd, 3rd, or 4th of September.
Till 2nd, 3rd of September.
3rd of September.
Interim order till 3rd.
I'm grateful.
Next. 18 हो गया? इसीलिए नहीं करना, जिस लोगों को क्यों डेट दे देते पहले मेंशन करके, अपना आप से बोल दिया नॉट टुडे, किसको मेंशन किया? हम तो बोला लेगा, आप बोल दिया नॉट टुडे, नहीं होगा, तो हटो. Don't take your own decisions, sir. He mentioned, I told that yes, I will take. Yes, 19.
Item 19, Mr. Shabir Ahmed is appearing before. Mr. Shabir Ahmed is appearing before the petitioner. Lordship, he is engaging in other court.
Engaging in other court. So what will happen? What is the matter? Who is for the state?
We have served.
Who is for the state? The Union of it is the MES. Have you served? Where is the affidavit service?
Lordship, service is. They have received by personal hand service. It has been served.
To whom?
To the office of the Union of India.
There are so many respondents, so altogether 7 respondents. Where is the service? You served only one. Senior government advocate. Strand Road and Chief of Army Staff. Yes, sir. Where is for the other?
Lordship, the
Lord-
chief officer I have sent through.
Lordship, I am appearing for the Union of India in this matter. Lordship, I am in some difficulty, Your Lordship. There's a medical issue. Your Lordship, can I please seek a not today for today, Your Lordship?
Lordship,
You are appearing for whom?
Union of India.
For the Union of India, Your Lordship. This matter will have to be heard at length, Your Lordship. I'm humbly praying for a not today.
Okay, then who is appearing for the Chief of Army Staff?
I am only appearing, Your Lordship.
All respondents?
Yes, Your Lordship. But I am in a grave difficulty today, Your Lordship. So I'm praying for tomorrow, Your Lordship.
What is asking? You are appearing for all respondents?
Your Lordship, I'm
Yes,
led by
yes,
Mrs.
yes, Your Lordship.
Yes, Your Lordship, I'm led by Mrs.
Yes, yes.
Affidavit of service filed by the petitioner be kept with the record. So and so appearing for the respondents and praise for time according cases adjourned. When? An interim order?
No, Lordship, this is the motion stage first hearing, Lordship.
So let the affidavit file. Without affidavit can be decided. What is your prayer?
Lordship, my prayer, Your Lordship.
The interim order you ask for. Stay the operation of the interim order 123. Okay. Let the matter appear on 9th July under the same heading. Next.
I am so grateful to Your Lordship.
18 कहाँ है?
In 18, Lordship, I'm from the Union.
But when petition is not here,
Waiting and then go. That's kindly not today.
come tomorrow.
Yes, grateful, Lordship.
20, there is a confusion. Both of us are appearing for petitioner. It is a case solution.
Yes.
Shivani Maika.
Shivani Mikap.
Sorry, I'm 21.
Shivani Mikap.
And I am for the petitioner.
Yes.
And copy of the petition was served back in February. The issue is very short. In the 90s, there was a fraud of stamp papers. Now I am a victim of that fraud. And I have purchased a property. Till date, I have not got back the copy of the deed from the registry office.
You have to deposit the amount.
I am ready to do that. I have made a
But the
request.
state where is the say has come as courted hall.
And I will explain her in short.
Serve the copy.
And I am giving my copy.
You do one thing, madam.
Yes,
Here
ma'am.
nothing is there.
Yes.
There is a unless the deed is registered. There is a stamp scam in 90s.
Okay.
He is one of the purchaser. So there are several orders passed by the court to deposit the service. Let you take instruction. Come
Madam.
next week. I am fixing an
Yes, madam.
affidavit of service filed by the petition. We kept with the record. Counsel for the petition has served the affidavit, served the copy of the application along with the document to the land counsel for the estate. And counsel for the estate prays for time to take instruction. According case is adjourned. Let the matter appear on 9 July.
9684.
Yes, next.
21, my lord, I am appealing for the petitioner. Lord, this is the affidavit of service served all, my lord. Yesterday, a similar matter was moved by me.
But
Lord, that, my lord, with respect to, my lord, defreezing of bank account. My lord, from Bangalore, my lord, the police authorities have sent a notice to my banker, my lord, which is the respondents herein. And my entire business account has been seized, freezed. Now, my lord, I am in a position, my lord, where I do not know, my lord, at all, my lord, I am involved or, my lord, what amount the police is saying, and my lord has passed orders on these issues. My lord, only thing, let the bank let us know.
Who is for bank?
My lord, we have come for respondent number 6 and 7 for Kotak Mahindra Bank.
Kotak Mahindra Bank. How many banks are involved
There
here?
are two banks, AU Small Finance and Kotak Mahindra.
AU Small Finance. Duleshwar, Ajmer Road, Jaipur. Jaipur?
Yes, my lord.
So how the Jaipur branch will be here?
Now, my lord, this is the head office. My lord, branch office 5, my lord, sees. My account is in my lord branch, which is Gariahat, Kolkata.
Gariahat, Kolkata. AU Bank and
Kotak Mahindra.
Kotak Mahindra. Yes, what is your instruction?
Lordship, instruction is that we are acting upon the notice which has been given to the given by us to the police officer. Whatever the court orders us, we will comply to the order. Lord, in similar stance, my lord has entirely removed the freezing. But if that is the stance of the Kotak Mahindra, then my lord, freezing should go.
Where the notice is served to the police authority?
My lord, it's Bangalore. We have served. My lord, they have received, but the on the last matter also they did not appear. My lord, in last matter, my lord asked me to put them another notice and place the matter on 14th, so that
affidavit of service filed by the petitioner we kept with the record. In spite of service of notice, only the land counsel appearing for the Kotak Mahindra is appearing. None appears on behalf of the other respondents. Full stop. The respondent number 5, the branch manager AU Small Finance Bank, Gariad branch, as well as the Kotak Mahindra Bank, having the branch at Ideal Plaza.
No, my lord, Sarad Bose Road,
Sarad Bose
Ideal
Road,
Plaza.
Kolkata, are directed to file the report with regard to the status of the account of the petitioner and how many and the total amount pending in the name of the petitioner and the disputed amount with regard to the account of the petitioner. The bank also submit the report whether the bank has received any report from the investigating agency, that the investigating agency has obtained any report, any order from the court for freezing of the account of the petitioner. As none appears on behalf of the respondent number 8, the petition is directed to again notify the date to the respondent number 8 and to file the fresh affidavit of service on the next date fixed. It is made clear that on the date fixed, if none appears on behalf of the respondent number 8, appropriate order will be passed. Let the matter appear on 10th July under the same meeting within 10 matters. Next.
My lord, only one thing, my lord, since I have to serve the police in Bangalore, my lord, can it be 14th? Because last matter was also fixed on 14th.
14.
My lord was privileged, giving me privilege enough that first 10 matters, my two accounts, entire business is stopped. So can it be within the
That is
first,
there.
first 10 matters, my lord?
Next.
Yes, I'm for the trademark in this case.
Yes.
My lord, this is not that matter, my lord, where my lord, I argued on the point that a registration of a document, my lord, must be done in accordance with the law, my lord, which includes the section 32 capital A of the Registration Act. My lord, I had, my lord, on the last occasion argued, my lord, that 32A is a precondition of fulfillment of section 52. And my lord, the section 52, whereby my lord, endorsement has to be made by the registering officer. And my lord, section 52 is a precondition of section 59, where my lord, those are to be dated and properly marked. And my lord, section 60, which is the act of registration, my lord, must be must be done only after fulfillment of, my lord, these requirements of section 59, 52, and 32 capital A. Now, my lord,
Yes, what instruction you have taken? What is that instruction?
At first, I shall argue maintainability point and jurisdiction point.
Maintainability of point?
Yes.
What is the maintainability, sir?
My lord, petitioner did not find that which is to be proved that petitioner has a right title interest over the suit property. Petitioner only for find that the petitioner husband acquired that land. Petitioner husband died, but not
the prayer. What is the prayer in the
pair? This is the pair that 26th August 2020 that registered sale date which is executed by the respondent number 5 to respondent number 4 and which is to be set aside or cancelled before this court. I'm asking myself at first that petitioner has a right title interest over the suit property. Petitioner has filed that deed which is to be proved his right title interest. He did not file any annexure that petitioner has a right title interest over the suit property. Number 2 point, petitioner husband died, did not file any annexure that which is to be proved that petitioner husband died. Number 3 point, that is that petitioner claim, now first kindly look at the page, page 76. Page 76.
Yes.
That the petitioner husband property. Last line. Area is about 20 decimal. Last line, portion of the mark, then area is about 21 decimal. That. Malad, kindly look at the page 65. Page, this is the vernacular, Malad. Last line. Dagnong 8188 8 শতক 18 ওরকম ডাঙ্গা পরিমাণ 42 শতক, that means 42 decimal total land. Second deed which is to be cancelled, that is the claim, that deed is kindly mala look at the page mala page 6. Page 80. Page 80, only for that topsil, it is vernacular 8 decimal land. Only for 8 decimal land. Total 818 Dagnong and total land is 42 decimal and only for 8 decimal land, my lord, which is the sale deed. Then kindly, my lord, look at the page 88. Major information of the deed. Heading, page 88. Major information of the deed. My lord, first, second, seller details, name, address, photo, fingerprint and signature. Topon Kumar Das, status individual executed by attorney executed attorney. Last two line. Then, my lord, attorney details, page 89. Mr. Uttam Das and my lord, attorney of Mr. Topin Kumar Das. So, and ADSR my lord, filed a report that it is very much clear. That report, para 74. Para 74.
But he's going into the question of maintenance.
Let me finish my argument. Then copy acting copy আমাকে
Give the report. Give the report.
74.
Yes.
74. My lord. 74. The deed of sale, deed long such and such. That said deed was registered through a general power of attorney, deed long such and such, duly registered at the office of the ADSR, Rampurhat, where the attorney was representative and executed the deed on behalf of the seller, and he was the one who appeared before the concerned ADSR in person and presented the document. Therefore, after satisfying the person appearing before as the representative of the seller duly authorized to execute and present the same before the registering authority, the said deed of sale, where the photo and fingerprints, that is the main point, that the photo and fingerprints of attorney representative was affixed, was accepted for registration. That report is complete. Then, I am asking myself one question, that the petitioner filed one civil suit, that recovery of possession. When recovery of possession? I am asking myself, then that at first he has right title interest over the suit property and cancellation of the registered deed, that then he can pay. My lord, then that Civil Procedure Code Specific Relief Act, Section 31, it is very much clear, my lord. Section 31. Section 31, when cancellation may be ordered in person against whom a written instrument is void or voidable, and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may, in its discretion, so adjudge it and order it to be delivered up and cancelled. And second, two, this is a very vital point, very vital, Madam. If the instrument has been registered under the Indian Registration Act 98, the court shall also send a copy of its decree to the officer in whose office the instrument has been so registered, and such officer shall note on the copy of the instrument contained in his books the fact of its cancellation. Then this is purely a civil suit. Allocation 1 point, my lord, I argue. Because of that, at first, that deed court has no power to cancel the registered sale deed. Only for that civil court power, after trial and determination of the all parties and evidence complete, then if satisfied that that registered sale deed is null and void and nullity, then civil court give the judgment and decree. That judgment and decree, that registered can do that in book, in registered sale deed, that is, it is null and void. My lord, can you look at the, I have submitted the report, that para 60, registered ADSR. Same point is note, para 60. A registering officer cannot.
Para 60 now?
Para 60, but 60, page 2, 60.
60.
60. Can you look at this? A registering officer cannot unilaterally cancel a registered sale deed as it requires specific order of honorable court. A registering officer can only make notes on the cancellation of a document if a formal decree is obtained from civil court. This is very much clear at that point.
Sir,
So,
court is asking only one question to that. I already put the question to the petitioner with regard to declaring the deed null and void. It is only the civil court can declare. Now the petitioner has raised the point of law with regard to 31A.
32 capital A, my lord.
Yes.
32 capital A.
It is
32
executed.
capital A. In the kindly read the capital 32 capital A and the report which you submitted at page 74. That is in consonance or not?
Yes. Consonant. But because of that, that sale deed.
Please read 32A amended post proviso.
My lord, I can, my lord, hand up.
Person to present documents for registration. 32C. Yes. This is very much clear. By the agent or such a person, representative or assigned, duly authorized. Yes, power of attorney. By a power of attorney.
Come to proviso.
Executed and authenticated in manner herein after mentioned and registered at that point. I have arrived at 88 status and 89.
Sir, there is no difficulty with regard to the 32. The person can give the power of attorney. Power of attorney can execute. Kindly come to 32A. Read 32A.
No.
32A by some person executing or claiming under the same on the
You are not having the amended book.
Is 32 capital A এখানে আপনার
compulsory affixing of photograph etc. every person presenting any document at the proper registration office under section 32 that affixes passport size photograph and fingerprint.
Okay. Correct. Then come proviso. Come proviso.
Provided that where such document relates to the transfer of ownership of immovable property, the passport size photograph and fingerprints of each buyer and seller of such property mentioned in the document shall also be affixed to the document. Yes, this is the yes.
Read 74 read with proviso. Your paragraph 74 of the report which you submitted today and the proviso of section 32 capital A. Read. Your 74 read.
74.
Your report.
Your report.
Or I will issue the notice to the Advocate General to appear to address this court with regard to this issue.
The deed of sale, deed such and such was registered through a general power.
See, as per 74, it is your admitted case. The seller was not present. The seller has sold the property through the power of attorney holder. Power of attorney holder appeared before the sub-registrar and affixed the fingerprints and photographs. Correct?
Yes.
But the provisos, that is the question raised, is a law point question raised 32A. Where is the seller or agent or attorney? That is the only question, whether buyer and seller.
Yes.
It is not mentioned the seller through or his agent or representative or any other person.
In the deed, it is clear.
Deed can interpret the law. I am kindly see the last order. What order I have passed? What instruction you have to be taken?
I have to take instruction of the area, sir. That will be main point of thing.
This court find that the learned advocate appearing for the state not in a position to explain with regard to the section 32A of the 62A and the provision thereto with regard to the Registration Act 1908. Accordingly, Additional Advocate General is directed to be present in the matter to address this court in the matter. Let the matter appear on on 13th of July 2026. Full list of the Land Council for the petitioner is directed to note to issue notice to the Additional Advocate General to appear in the matter on behalf of the state.
Grateful, my lord. My lord, item number 24, I'm appearing for the respondent number 9.
My lord, on the last occasion, my lord's direction was to serve a copy to the state of West Bengal, intimating today's date, my lord. I have completely done that, and my lord, today Miss Sudipta Banerjee is appearing, representing the state of West Bengal, who is, my lord, the main answering respondent in this writ petition, my lord.
You are appearing for?
My lord, respondent number 9.
Respondent, my lord.
Okay.
My lord, in this matter, the main
Who has raised the mentality point? You?
My lord, I had raised it, my lord.
My lord.
My lord, I had raised it. Yes. My lord, because, my lord, I had raised it, the reason being, my lord, the issue, my lord, it pertains to the year 1999 when the government order was made. And my lord, they have come up before my lordships in the year 2026, my lord. And this is pertaining purely a civil issue, my lord. They want cancellation of my deed, my lord. My lord, a plot of land which was allotted to my grandfather, and thereafter by way of a deed, my lord, I have it. We are all refugees, my lord. My lord, the first government order, my lord, kindly comes to page 69, my lord, of my learned friend's petition, my lord. My lord, this is the first government order, my lord.
69.
Yes, my lord. My lord, 69 of the writ petition, my lord.
Yes.
My lord, by this government order, my lord, a scheme was taken out. My learned friend was also well aware of it, my lord, where, my lord, the displaced people from East Pakistan, my lord, they were given allotment of plots, my lord.
Correct.
My lord, not subsequently, because there were certain difficulties which were cropping up with respect to this government order. My lord, in 1999, my lord, a subsequent government order was again published, my lord, which is superseding the present 87 application, my lord. That is starting from page 72, my lord, bottom of page 72 of the application.
Yes.
My lord, in this particular government order, my lord, which is appearing at page 72, my lord, if it's, my lord, pleases it to go to the next page, my lord, that is page 73. My lord, there are two clauses which I would like to point out, which are the penultimate, my lord, bottom of the page, my lord. My lord, clause 2x and 2xi.
Yes.
My lord, here, my lord, in 2xi, it is stated, my lord, that notwithstanding anything contained above, person or persons in effective possession of the plot should be served with notice to sign the deed and to swear an affidavit within a specified date. And if they refuse to sign the deed, and for that matter refuse to swear an affidavit without informing the authority of any valid reason, then the deed may be executed in favor of the occupants of the family found otherwise eligible in respect of that portion of land which is in their respective exclusive possession after due service of notice upon the recalcitrant occupiers of the portion of the plot. My lord, this petitioner, my lord, she is the sister of the respondent number 9. My lord, she was married off in the year probably 1993, 1994, my lord. My lord, thereafter she moved out of this particular house, my lord. She was not part of the joint household. My lord, all one fine day, my lord, in the year 2025, she makes an RTA application because she realizes that she has been cheated by her brother and she has not got a share of the plot which has been allotted to the brother by way of a registered deed, my lord. My lord, that also my learned friend's writ petition will be substantiate, my lord. That is appearing at page 84, my lord, of the writ application, my lord. My lord, it is a memo issued by the concerned department, my lord, in reply to the RTI of my learned friend's client. My lord, page 84, it is memo number 195 stroke CDR stroke SQC dated 13/11/2025.
Yes.
My lord, in this particular reply, my lord, it is categorically stated, my lord, that the deed was executed in the year 2005, my lord. My name is appearing Shamol Dash, my lord. 1, 2, 3, 4, 5. My lord, the fifth line, my lord. Shamol Dash, son of Shottaranjan Dash, being deed number 47 of 2005.
Yes.
She is aggrieved by this, that she was kept in the dark and a deed was executed. My lord, if she wants cancellation of the deed, she has the remedy before the civil forum.
Yes. Okay. This is an objection. What is the prayer?
This is my case, my lord. Initially, I will just point out 2 pages to my lords because my learned senior friend is intentionally pushing only those points which falls in his favor.
Page number 70 is, my lord, my first point.
70.
Page number 70. That is the first 1987 notification, my lord,
Correct.
which my learned senior friend first informed, my lord.
Yes.
Kindly sees, my lord, clause number 4 and 5. Clause number 4. In case where the allotee or Orpan Potra holder or regularized squatters is found dead, freehold right and deed should be executed in favor of the person stroke persons exercising possession, provided that such persons belong to the members of the deceased allotee, and swear an affidavit beforehand declaring inter alia that they are the only persons in effective possession or along with some other eligible persons to be named. Thereafter, my lord kindly sees, if the declaration in the affidavit in such cases are subsequently found to be materially untrue, the title deeds will be liable to be cancelled. Then, my lord, I should ought to submit that if they have got the deed, the other co-personers, and if they have submitted this affidavit before the authority, then the substance of that affidavit is materially untrue. And who is going to decide that? The RR department.
When the deed was executed.
This deed was, my lord, executed in 2004, and I have taken my specific my lord, averments in the writ petition in page 4 to 6 that we were there in effective possession in that property.
Correct.
We were there in effective possession because the entire thing held behind our back.
You are claiming the property in terms of the guidelines.
My lord,
In
my
terms
lord,
of
but
this 87 guidelines.
and thereafter another point, my lord, kindly takes page 75, the 1999 notification.
Yes.
75.
Page 73, my lord.
Yes,
Page
sir.
73.
My lord, I am referring to paragraph number 4. My lord kindly sees.
Yes.
Is the relevance of coming up with this 1999 notification when 1987 notification was already there? The reason is this. In a large number of cases, the original allottees regularized to squatters have expired. The legal heirs in effective possession are required in pursuance of
Don't use the
the
data. It's
such
disturbing.
and such, that is not the 87 notification, to arrive at a common accord before the concerned plot can be subdivided and title deeds issued in appropriate cases to the eligible heirs. Thereafter, accordingly, if one or more of the heirs do not give consent, deeds cannot be executed, deeds cannot be issued over such portion of plots which is in effective possession of the other eligible legal heirs. Now, my lord, where is my right to object?
No, see. Your right is created 87 in terms of the 87 scheme.
My lord.
Correct.
My lord.
87 scheme subsequently amended in 1999.
My lord.
Correct.
My lord.
So your claim is that in terms of the said scheme, the land was allotted and you are in occupation of the property in question.
My lord.
Behind your back, the private respondents have sold the property in 2005.
Private respondents have not sold, they have got the deed from the RR department.
Correct.
I am challenging the process.
They got the deed in from the RR department.
My
Where is the deed?
My lord, I am in hold of only one deed. That's why I have represented that one person in the private respondents. But that one deed clearly shows that the plot has been subdivided also, and 3 separate deeds also been mentioned. My lord.
This,
Page number 35, it was issued in 2005.
Page 84 says, EP number 170, which area, which survey number you are praying, you are claiming the title.
My lord, EP number 178, SP number 187 of Shohid Sunilnagar colony was the original mother plot allotted to my grandfather.
Arendranath Das was your grandfather.
My lord.
Correct. And the above noted plot subdivided in 4 parts.
My lord.
Correct.
My lord.
In so and so, so and so, so and so, so and so.
And this, my lord, also cannot be done. I can show it to your lordship from the answer I have taken from the RTIs, my lord. In RTIs, RR department clearly says that they cannot subdivide a property without an amicable family settlement. And in my limited understanding of law, my lord, I understand an amicable family settlement can only be occurred when all the existing co-personers be intimated.
Correct.
Where is my right? That is my point. I am not, my lord, per se challenging the veracity of the deed. I am, my lord, challenging the process which has been adhered upon to issue that deed. And how can a civil court determine that whether the government's policy have been followed by the government itself or not?
Why not? If you go as per this RTI, the land is allotted in the name of the Shamal Das.
My lord.
Recorded in the name of the Shamal Das as per the deed.
Subdivided, one portion is named. My lord.
You are claiming against the Shamal Das only.
I am claiming against the entire plot, my lord.
Who are the parties here?
My lord, I am not in hold of the other deeds. That's why I have only
Your grandfather is there.
My lord.
Your grandfather is alive.
No.
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 Your grandfather is how many children are there?
My lord, kindly sees page number 84 then.
Yes, 84.
83, my lord. It's a family tree annexed with my RTI application, my lord. Kindly sees. This is, my lord, the family tree.
83.
Harendranath Das was the original allotee. My lord can see it from the page number 85. The conduit register has been given by the RTI reply. Thereafter, my lord, Shotya Ranjan Das, Sudhir Ranjan Das.
No,
Can
this
only claim this.
and by the authority. Page 83.
No, my lord.
No, this is a portion. This
You
is
have
a portion I have prepared, my family tree.
So the original land allotted to Harendranath Das.
Harendranath Das.
Correct. Harendranath Das having the 5 legal years.
5 legal years.
5 legal years. So as per your case, if the Harendranath Das has expired and his wife is also expired, so the property is to be mutated in the name of the 4 legal years.
Four legal years, and my lord,
Five legal years.
out of them, my lord, Shotya Ranjan Das, who is my father, expired, my lord.
Prior.
My lord.
When he expired?
In 2003.
2003, but prior to that, till 1992, he was there when the
my lord.
1982, when
Before the deed was issued, my father expired. Therefore, my right opens up, my lord. When the deed was issuing, at that point of time, my right was there, my lord.
Correct. So deed was executed on when?
2005.
2005. Correct.
And 2003, my father expired.
2003, your father expired.
And I was there in possession.
You are in possession.
And I am a legal heir.
Correct. So what the writ court will do here?
Milord, I am not, Milord, per se against the veracity of the deed. That can be determined by the RR department also, because clause 4 says that they can cancel it.
Not deed, not cancellation of. You are telling that you acquired your right in terms of the 83 scheme, 87 scheme and 99 scheme from your grandfather.
My lord.
But the authorities, instead of mutating the property in your name without your consent, the land was subdivided and one of the portion has been deed has been executed in favor of the private response, Shamal Das.
My lord, we were entirely behind our back. This entire process was started.
Behind your back.
So, which is against the policy.
So, rightly or directly or indirectly, you are claiming the property in question.
My lord, I am not per se, my lord. I do not have the audacity to claim a property before a writ court. What I am asking is,
that's why what you are claiming. So if you are telling that the court set aside this deed and set aside the subdivision, then you will get the property. So
I am just seeking a complete consideration of my final representation at page 87, so that all the parties can be brought up together by the RR department and the entire discussion can be held before them, whether we were there or the affidavits given by them are wrong or not.
Have you filed an application before the authority for recalling of the order and recalling of the deed?
My lord, this recalling of the deed I have asked
where in
my final representation, my lord.
Final representation.
My lord, kindly sees. My lord, my final representation is at, my lord. Page 76, my lord, my final representation.
74.
And nothing, page 76. And nothing was done. Page 74, my lord, I have also taken out the facts that what I have come across from the answers of the RTI. I have mentioned them.
Okay, let the authority decide this.
That is my point. I am not against their right. They are also their legal right. They are admitting my right. I am also admitting their right.
Decide this.
I am not saying that they are not the legal heirs of Harendranath
Well,
Das.
let the authority decide, my lord. Let the authority, my lord, let the authority decide, my lord.
My lord.
My lord.
The petitioner has filed the present application with the grievance that the petitioner has made a detailed representation to the concerned authority on 25th of October 2025, requesting the authorities to cancel the freehold deed and requesting the which is the authority respondent number.
Respondent number, my lord, the RR department. It's my lord, the respondent number.
Respondent number 3, 4. Respondent number 4.
Respondent number 4, my lord.
क्या बोला?
The appropriate authority. Respondent number 4.
As follows.
And my lord, 3 also.
No, you have given the representation to whom?
My lord, I have given the representation to respondent
FTR.
number 4.
4.
Respondent number 4.
Respondent number 4. Respondent. Huh? 379. Yeah. 1. Yeah. Okay. Full stop. The contention of the petitioner is that the grandfather of the petitioner, Harendranath Das, has got the property in terms of the scheme of 1987. But the authorities without the consent of the petitioner, who is also one of the legal heirs of the Harendranath Das, had subdivided the property in 4 parts, and one part has also been and with respect of one part, a deed has been executed in favor of the private respondent.
My lord.
Private respondent. Though the petitioner is having the right over the property, and the petitioner has not been given any opportunity either at the time of subdivision or at the time of execution of the deed in favor of the respondent, private respondent. Learned counsel for the private respondent raised the question of maintainability of the present deed application and submit that the petitioner has claiming his right, title, and interest with respect of the property by way of writ application. He further relied upon the scheme of 1987 and 1999 and submit that the authorities have acted in accordance with the said scheme. He further submitted the petitioner has challenged the deed of the private respondent, which cannot be challenged in the writ application if the petitioner is having grievance against the said deed, the petitioner could have filed civil suit. Had the learned counsel for the respective parties produced the materials on record, this court find that the grievance of the petitioner in the present writ application, that the petitioner has raised his grievance before the respondent number 4 by way of representation dated 5th of October 2025. Prior to that, also the petitioner has made the grievance, but the respondent authorities have not considered the request of the petitioner. Accordingly, without going into the merit of the matter, this court dispose of the present writ application by directing the respondent number 4 to consider the representation of the petitioner by giving an opportunity of hearing to the petitioner as well as the affected parties, and to pass a reasoned and speaking order within a period of 10 weeks from the date of receipt of
Deeply
this
obliged.
order.
Deeply
It is made clear that this court has not gone into the merit of the matter, and the authority, the respondent number 4 is at liberty, shall decide the matter in its own merit.
Grateful, your lordships.
Deeply obliged.
Next.
Madam for the petitioner. Last August, Lordship directed to serve a copy upon Ms. Sudeepa Banerjee and Madam.
Yes. What is the matter?
The petitioner is a government contractor, and he regularly appears before the different tenders and also completes the work upon issuance of the work order. My lord, in the year 18/7/2025, my lord, one tender was issued. No, before that, in the year 2024, the work order is issued, and 28/6/2024, work order is, my lord, and tender was issued, and he participated. And after that, he made a offer of 49.99% less of the tender value. For that, he got the work order. Work order issued, my lord, on, my lord.
Where is the tender notice?
With the previous tender order. Work
Page
order issued
22.
24. 20,
Tender notice?
Tender notice is, my lord, annexure P1, 28/6/2024. Is the previous.
Page 22.
Is the previous one.
Then,
my lord, the work order issued, my lord, 23rd of July 2027.
where is that work order?
And the work is to be begin in 20.
Where is the work order?
At annexure P2, my lord.
P2?
Yes.
Where is that?
At page, my lord, 27.
27?
Yes. And the work is to be given, starting the next day, and on the day after next, my lord.
What is the work order? Training cum workshop on management of man-animal conflict in Southwest Bengal at STFTI. Yes.
Yes. So the next day he went to the bank for issuance of the bank guarantee to be submitted for the work, my lord. But for technical difficulty of the respondent, the bank guarantee, the IFSC code and the other different could not be given, and bank guarantee could not be issued. So for the urgency of the work, my lord, respondent number 4 and 5 verbally asked the petitioner to complete the work without submission of the bank guarantee. So he completed the work successfully, and the bill.
Now, the work order was issued on 23rd of July 2024.
Yes.
Correct. When you have to deposit the performance guarantee?
On the next date. On
where is the terms and conditions of the performance guarantee with regard to the tender? Where is that?
That should be with, my lord, respondent authority, but my lord, performance guarantee is to be issued before, my lord, the work is to be completed, and also before, my lord, the bill is to be paid, my lord. Payment is to be issued, but bank guarantee could not be submitted because due to some technical difficulty of the respondent. So, my lord, work was completed, bill was generated, and bill was paid, my lord. There is no dispute. Then, my lord, in the next year, again, my lord, another work order issued.
Without the performance guarantee, bill was also paid.
Yes, yes.
Very good.
For
then.
my lord, their problem, because their IFSC code was.
Correct. Net, what has happened? Again.
18/7/2025, another work order, another, my lord, tender was issued, but this petitioner also participated again, my lord. Here, my lord, one, my lord, show cause was issued that the previous in the previous work, some bank guarantee was given by the petitioner that was found now at this point of time as forged. And on the 7 August 2025.
Where is the show cause notice?
Yes, my lord. At page annexure P7, page 56. At the petitioner specifically again and again stated that he has not given any bank guarantee.
Page 56.
Page 57.
Yes, so cause notice.
56, yes. 57.
So?
Now he was a show cause, and thereafter he has been debarred to participate for 2 years.
You are informed the bank guarantee number so amount to 34,000 submitted by you against the work order number itna. That is with regard to the 23rd July.
Yes.
2024.
Previous one. And if at all, my lord, bank guarantee was given, at that point in time, it has to be scrutinized before.
So cause notice. So what is your so cause reply?
At page 58, annexure P8, I categorically stated that I have not issued any bank guarantee. Then
Page 58.
59, then 59, then my lord,
The bank guarantee number, you have not issued that.
no, I have not
Guarantee
issued-
number is there,
Yes,
amount is
I
there.
have asked for the copy of that bank guarantee that was alleged to be given by me. That was never given to me. I made an application, I made an application on RTI. It was never given to me.
So what is the reply to the so cause?
And after the show cause, my lord,
What is the reply, sir?
my
Open
lord-
the instant false allegation regarding forged document pertaining to the work completed more than 1 year. Yes, then
Then my lord, one authority has started on investigation at page 60. There also I stated that I have not issued any bank guarantee.
I cannot.
Then my lord, the punishment is given.
So then what has happened?
Then my lord, order is issued at page 66.
What is that? Page 60 onwards, what is this?
That is, my lord, the written statements made before their before the authority. The copy was not given. This was taken by the petitioner. It is a cross, chief and cross before their authority. Then my lord, order was given at page 66 and it's a P11. Entirely
Page
66, my lord. The order was given entirely ignoring my point that I have not issued any bank guarantee and I've been debarred for a period of 2 years from participating in any tender.
Which authority? Forest?
Yes, lordship.
Yes, madam. What is your instruction?
Hello. Well, firstly,
Copy may be given.
firstly, petitioner alleging that the bank guarantee number has not been provided, but fortunately or unfortunately, they have annexed P11 page 66, my lord. There is clearly stated the bank guarantee bearing number such and such dated 25/7/2020.
Page
That is the
66.
allegation.
Page 66 is your letter.
Yes, my lord. There is clearly stated the bank guarantee number, which they have claimed.
Correct. Where is the bank guarantee? Which you are telling that is a
Yes, my lord. That I have.
where is that? Where is the false? Where is the bank guarantee? Which you are telling that he has submitted the false forged bank guarantee. Where is the copy of the bank guarantee?
My lord, annexure D of my report, my lord.
Annexure D, page
Page 15, my lord.
15.
There is a verification from the bank's end, my lord. And there is clearly stated bank that the document, the bank guarantee document submitted by the side party is not genuine and appears to be fake, bearing such bank.
This is the report from the bank.
Yes, my lord.
It is
Bank
not the bank guarantee. It is not the bank guarantee.
Verification
bank
bank
guarantee.
guarantee submitted by the Mrs. Sai and
Where is the document that he is informed you this is a bank guarantee? Where is that letter? See, tender was issued.
Yes, my lord.
After the tender was issued, the work order has been issued. Work order has been issued, so the petitioner has to give the bank guarantee.
Yes, my lord.
Is to be open and the copy is to be served to you, which is to be time to time it has to be extended. Where is the bank guarantee submitted by the petitioner to you? How you can come to know this is the bank guarantee? Because the bank is telling that no such bank guarantee. So how you can come to know this is the bank guarantee? Bank guarantee might be in your document.
Yes.
Which bank guarantee has open, it have been submitted to you only. It is not the bank guarantee is open and is kept in the bank. Bank guarantee has to be submitted to your office. Then only you can allow it to continue the work.
My lord, they have not filed the.
Who has not filed?
Department, my lord.
Take the department instruction.
Then my lord.
See, the only case is that 2023, the work order was July 24, work order was issued. He has to submit the bank guarantee. Now you have taken the plea that the bank guarantee which he has submitted that was forged. So which bank guarantee? Neither the bank guarantee was sought to the petitioner and the bank and the page 15 which you are relying upon. Bank. So what is the document sent by you to the bank?
Then I shall take.
Where is the bank guarantee?
Yes, my lord, that's the main.
He is telling that I have not submitted. So which bank guarantee you verified?
Then my lord, I have to take instruction. Where is the bank?
The petitioner has filed the present writ application challenging the order dated 12th of September 2025, wherein the petitioner has been debarred for participating in any tender or quotation work under the administration control of the Development Circle of West Bengal Forest School, Dove Hill and State Forest Training Institute, Hijli, with effect from the date of issuance of the order. The only allegation against the petitioner is that the petitioner has submitted a bank guarantee being number 10404021L G 001523 dated 25th of July 2024 amounting to rupees 37,475 issued by the Punjab National Bank is forged one. Punjab National Bank IIT area branch, which is forged one. The learned counsel for the this is a specific case of the petitioner that the petitioner has not submitted any bank guarantee. The learned counsel for the state has submitted the report and relying upon the report of the bank officer of the branch manager, Punjab National Bank IIT area Kharagpur branch dated 7th of August 2025, wherein it is mentioned that after the verification of the record, the bank guarantee has not. It was confirmed that the bank guarantee has not been issued by the said branch in favor of the petitioner. But neither the instruction submitted by the respondent does not disclose which bank guarantee has been submitted by the petitioner to the authorities and which bank guarantee has been forwarded by the authorities to the bank authority. Accordingly, the respondent authorities are directed to place the bank guarantee, alleged forged bank guarantee, which is the subject matter of this case, before this court on the next date fix. List the matter on 17th July. Grateful, Lordship. Yes, next. बंद करो original sir.
Number 20. My lord, item number 20 of your lordship's daily list. Lord, this is a writ petition on 1992. So there's a GA application which has been filed. I am not saying there is any crying urgency, but there is an urgency.
Why 1992? What is the matter now?
No, the matter has been continuing, orders have been continuing. We'll need further orders to complete the process.
Okay, so what do you want?
Basically, my lord, we want certain orders upon the receiver to complete the process which has been continuing since 1992.
Who is the receiver? Advocate?
What is the name? I'll just give your lordship the name of the receiver. Naam ta bolun na. Day. We'll put him on notice as well.
What?
Any day convenient to your lordship, my lord. It is appearing as item number 20 in your lordship's supplementary list.
One further order in the matter.
Yes, please.
Who is for the respondent?
Respondent technically is
State.
no, just the receiver, not the state. Well, this is that under the against the arising out of Industrial Restructuring Bank of India under the IRBI Act.
है इसका फाइल है
नहीं आया नहीं
कब रखिएगा 29 July at 29
Very well.
Record an order. Though the matter is listed as item number 20 in the days list, Land Council for the petition mention the matter and praise for fixing a specific date and time for hearing. Let the matter appear on 29th.
29th, your lordship has been pleased to fix that Roshniwal willful default as matter at 3 o'clock. So this will not, yeah, this will not take much time.
29th of July 2026.
Very well.
At 3:45 p.m.
Deeply obliged. Deeply
The
obliged.
petition is directed to notify the date to the receiver
My lord.
and the parties, if any, appearing in the
Very
matter.
well. Deeply obliged. Deeply obliged.
Next.
It a
As
detailed.
well, Lordship.
Yes.
My lord, this particular matter is item number 9 in your lordship's list. However, my lord, my client has been regularly suffering for more than a year and a half now. There's a loan basically which has been squared off by my client, and the deed has been misplaced by the bank, the respondent
So
bank.
what do you want?
My lord, if there's a GA also
You have
pending.
taken loan. Bank has lost the deed. Need not to pay.
My lord, the payment has already been made.
What do you want now?
My lord, if your lordship is pleased to fix up the matter,
What is the payer?
My lord,
You
it's-
already
it's
paid
for
the-
reconstruction of the deed, my lord. For
Reconstruction of the
not
deed.
reconstruction of the deed. It's basically for applying for a certified copy of the deed, and there's a GA also pending with regard to some amendment in the writ petition, my lord.
It is 9 already. It is there. If matter
Lord,
is adjourned automatically, please wait. It will be taken. One fixed matter is adjourned, then automatically I will call the matter. ठीक है इसको रख दो कोई बीच में Yes.
Deeply obliged.
With your lordships, kindly, I would like to mention item number 60 of your lordship's list. There is a urgency in this matter. If
Every
this
urgency,
matter-
what can be done?
There is a seepage due to this heavy rain, your lordship. There is a seepage in the roof and every floor.
So what
That
you
is
pray-
why
what you pray
for
for?
early hearing, the pleadings are complete. For
Who's for
early
the other
hearing of
side?
this writ, I have served the state, and there is one private respondent.
It cannot be upgraded because several matters are fixed. Fixed matters are there.
Lordship would kindly fix one date for this matter. I have got photographs also, just to show the condition of the building.
Who is for the other side? Item number 60.
Item number 60.
You are
I'm appearing for the state.
Yes, state. State, what is the writ petition?
It's for the cancellation of the ownership association.
So what is the structure is, you're telling the structure is in damaged
The
condition?
structure is in damage because of the rainwater, your lordship.
So what is
So
the
they're not doing any kind of renovation for this. That is why your lordship is
who is
required.
not renovating?
The association who is there right now.
Association. You are the
I'm petitioner. I'm one of the minority
one of the member of the association.
member of the flat owner.
So why you are not going to the authority council?
We have gone
Then?
twice.
Then?
No
No.
steps.
क्या करेगा? It will go 4th August. If you try luck in
Okay,
the
your lordship, if you kindly fix this in 4th August.
though the matter is listed as item number 60 in the days list, but the land council for the petition submitted praise for fixing a specific date and time. Accordingly, case adjourned, let the matter appear on 4th August at 3:45 p.m. 3 p.m. provision. Next.
Obliged.
My lord, GA3 in the suit, my lord. This is for acceptance of the written statement filed beyond time, my lord. Mr. Thakkar is leading me. Mr. Thakkar, my lord, this is that suit. Circuitous transaction, my lord. Circular transaction. Your lordship has now dealt with GA1 finally. GA3 pleadings are complete.
Do one thing, all petitions including suit will be dealt by this court. I will fix 2 days, continue morning to evening.
I would
morning
be
to
glad.
evening.
We all will be glad. The people you are suggesting this,
I
we
will
all
be
will be glad.
I am not aware exactly of the sentiment of the defendant.
We have no issues.
Yes.
Miller, pleadings are complete. This is their
Now,
application.
return of the affidavit filed.
Yes.
Affidavit
Opposition
filed.
reply put.
Lordship,
Reply
Miller,
filed.
I'll be very candid before you, Lordship. Miller. Written statement has a counterclaim. Of course, this is a non-commercial dispute. So written statement, I am not standing in the way, but commercial dispute, I have some difficulty. But counterclaim, I have something to say regarding the institution of counterclaim before this honorable court. So I have taken this point of demurrer at the very threshold when they have made an application.
No, it is not a commercial suit.
Money lent and advance matter,
Correct.
not a commercial dispute.
Correct.
Now, my lord, defendant has filed an application for leave of this honorable court to allow them to file their written statement, which contains a counterclaim. The written statement is annexed with the amendment, with the application, and we have seen that there is a counterclaim with that. Now, my lord, there has been, of course, hearing of GA1 and extensively. So that took some time, my lord, for the written statement, which I understand justifiably for them to bring on board. I may not stand in the way of your lordship granting them leave to file their written statement, but I have something to say, my lord, with respect to the institution of the counterclaim. That is the only leg of my argument.
What is the objection?
Well, the objection are twofold, and I have already stated in my affidavit that the cause of action has not arisen wholly within your lordship's jurisdiction as far as the counterclaim is concerned. So no leave under clause 12 is sought. So they will have to, my lord, once the written statement is like, my lord, counterclaim is like a plaint. So once
Okay,
that is presented, and then second thing, my lord, according to us, with deepest humility, my lord, the counterclaim is barred by the laws of limitation, ex facie. Any day, but my lord, this is actually my argument. So it won't take much time.
To be mentioned on the prayer made by the counsel for the parties. Then counsel for the defendant number. Defendant submit that. Defendant submitted. The defendant filed an application being GA 3 of 2023 with the prayer for acceptance of written statement along with the counterclaim. Then counsel for the plaintiff submit. The plaintiffs have already filed the affidavit in opposition and the reply is also filed. And the matter is ready for hearing. Let the matter appear on 4th August at 3 p.m. 3:45 p.m. for hearing of GA3 of 2024. GA3 of 2023.
Lord, can it be on the 5th of August?
5th of August.
Same time.
3:44. Next.
Matter, I think we have to again serve the change in that. Pleadings are complete.
But Milord says that there has been change in the panel, Milord. They should supply us a copy.
You are appearing for?
State.
State. So you will get the you are not a copy. You not get the copy of all these things.
No.
So
the office of the
I'll be good.
Though the matter is specially fixed today at 3 p.m., but there is a change in panel of the state advocates. Accordingly, the learned advocate is appearing for the learned advocate is appearing for the state submitters is not having the brief of the matter and prays for a direction upon the petitioner for service of the copy of the writ application along with all documents. Accordingly, the petition directed to serve
along with all the pleadings, Milord, because we
according petition directed to serve the copy of the writ application along with all the pleadings to the learned counsel appearing for the state by tomorrow, within a week. Within a week.
we hold matter, we should have some breathing time also.
Of course, Lordship is giving Lordship will not give
Within a week, full stop. List the matter on 4th August at 3:45 p.m.
Obliged.
Next.
Number 4.
I agree on behalf of the petitioner. Lord, Lordship will recall, Lord, several adjournments were taken on the last 3 occasions.
I am for the bank matter.
Lord, I'll tell your Lordship very quickly what the matter is. Lord, Lordship will recall, this is a tender which was awarded to us, Lord, the petitioner,
by the CWC. Lord, CWC,
My seniors are
what's
on
the
the way.
tender? Lord, this has been going on from 2006. The first tender was from 2006 to 2011. The second one was from 2014 to 2018. And the final tender, Lord, was 2019 to 2024. Lord, now what happens is, Lord, we under the tender, Lord, we have to give, Lord, performance bank guarantee and an additional security. Lord, amounting to, Lord, approximately 85 lakhs as performance bank guarantee and security deposit of 42 lakhs. Lord, this has been given. Lord, now this final contract of 2019, Lord, this comes to an end in 2025. Lord, there's a defect liability period whereby I've been told to enhance to increase the time of the bank guarantee till 2026. I do that. Lord, once the contract is completed, Lord, thereafter, Lord, a notice is issued by Lord the CWC saying that now this area, this port area is being taken over by the LPA, Lord, Land and Port Authority of India. Your services are no longer required. Lord, I furnish a letter that all right, Lord, I am giving back the possession of the property, and now
give the amount back.
Yes, now please return me the PBG and the additional security which I have granted. Lord, all of a sudden, Lord, there is a letter which is issued to us saying by the bank, by HDFC Bank, saying that there is a request which has been received. 3 crores odd money is lying due from to CWC. CWC wants to invoke the bank. Lord, now when we check up, Lord, this particular 3 crore 49 lakhs odd which is there, Lord, relates to a contract in 2006, which has been concluded in 2011. Lord, the claim is on account of refund of excess security service tax, which has been given in 2011. Lord, now coming to the second part of the story, Lord, I'll start now. Lord, 2011, when they make this demand, Lord, I file a writ petition. Lord, a learned single judge of this honorable court, Lord, directs that let there be an adjudication. Lord, the regional manager is directed to adjudicate. Lord, on that, Lord, the regional manager, being the own CWC's own person, passes an order saying that yes, you have to give. Lord, we file a fresh petition asking them to stay this demand. Lord, the demand is stayed. Lord, there are observations of a learned division of a learned single judge of this honorable court saying that CWC cannot be the judge of its own cause. It cannot say that yes, you are the person who wants the money and you are the person who's going to adjudicate that claim. So, Lord, this is set aside. Lord, the letter is set aside. My learned friends prefer an appeal from that same, Lord, the order. Lord, no interference. Lord, appeal is still pending even as on date. No stay. Lord, now in a circuitous way, in order to bypass.
What your challenge here?
Lord, essentially, Lord, I am asking that this invocation is wrongful. Lord, this money has to be returned to me. Lord, it's completely arbitrary. Lord,
the revocation is wrongful, that already appeal is pending.
Lord, and that is the exact reason. Lord, during the pendency of the appeal, the court has categorically held that you're not entitled to receive this money back. Now, in the guise of Lord, a fresh contract, now they have sought to invoke this, saying that use of Lord twofold contention. One is that Lord was completely stale claim. Lordship knows 2011 claim. Lord, they seek to get that money by in 2026. Lord, completely barred by limitation. And the second, and Lord, I would respectfully submit, possibly more glaringly, Lord, in the teeth of 2 orders of this honorable court. Lord, may I show you your Lordship?
Yes.
Order, Lord.
Ramp of bank, mother.
My lord, I'm praying for a short passover. My senior is on his way. He's coming in.
Who is your senior?
Samrat Chaudhary.
I'm addressing your lordship.
Lord, and on the last period, it concluded a submission. Lordship was pleased to Lord, adjourn it on this prayer.
That's why I want to hear you.
Short passover.
Lord,
what can be done?
Lord, we be here.
Yes, next.
Your Lordship, I am appearing for respondent number 7 and 9. Your Lordship, before my learned friend proceeds, let me indicate there are certain persons who are died. They have to be substituted, Your Lordship.
Certain persons have died.
Yes, Your Lordship.
My case, Your Lordship.
Them as a party, they have
But
died.
may I place my case?
What is
This is a case, my lord, an illegal and unauthorized commercial kitchen
is operated from the ground floor of my premises.
Your Lordship.
Your Lordship knows,
Permission.
my lords knows, well, there is a notification which identifies high risk building. Well, to operate a commercial kitchen, article Your Lordship requires fire safety certificate. My kindly takes the photograph that I've infused with it.
Who are you?
But I am the owner of premises number 3.
Who are the number 3 and 4?
Respondent and 4 are the authorities, Your Lordship.
Correct.
And respondent number 6 is the partnership firm 70.
Who died?
Your Lordship, I have.
Who died?
And Lordship indicating it. Your Lordship, 11, 13, 15, 16, Your Lordship. They have died. They have to either be substituted or have to be.
Yes.
Without that, a dead person cannot be implemented. Your Lordship.
That's correct. So if you want to substitute, you want died, you will not substitute, I will record the
partnership form is Your Lordship.
The court can't say why. Now they are submitting you and submitted before this court that 11, 13 and 15 are no more.
No more. How can be the
Correct.
party? Yes.
And 16. Without passing any order, if any court has passed any order, your order will be null and void. So either you take steps, either to substitute. If you say no, I will not substitute, their name be deleted. I will pass an order for deletion.
Let
This, what about the
my submission is also since the partnership firm is given record. Any we can and
then
in my handle commission.
Then first let them
I will pass an order for deletion. You let the proceed. Yes.
Well, it kindly comes to page number 21.
Yes.
Outdated structure.
It is a kitchen or it is the what we call
commercial kitchen. Well, it automobile used.
It is your premises.
My premises. I have what
Object to this, I'll
give you opportunity to you. Let he submit.
Yes, Your Lordship.
Malit, this is in the heart of Malit, the commercial hub in Chandni Chowk, Ankur Chandra Street, and 5 Ankur Chandra Street. Within 5 premises number 5 on the ground floor, there is a restaurant called Sabir's. That restaurant, responsible for that restaurant, to runs a commercial kitchen in the.
What is the restaurant?
Sabir's Hotel, Your Lordship.
Sabir's Hotel.
Sabir's
Hotel, yes.
My lords. The kitchen which served the restaurant, Your Lordship, is on my premises in the ground floor. And after acquiring the property, this commercial kitchen on record. Despite the seat of this representation, well, this is a serious budget. The serious question on the city, not but in the entire locality. I mean, may I just please communicate the document? Then I'll take a lordship to the law.
Oh, premises number 3 is yours.
My lords.
Premises number 5.
Well, it is the adjacent premises.
Not yours.
Not mine, Your Lordship.
Then?
Well, the commercial kitchen is operated from my premises.
Of Biplav number 3, 3 Biplav Anukul Chatterjee.
My lords.
Yes. Then?
Well, it kindly takes the annexures, Your Lordship. Page 21, Your Lordship will find the state of affairs in which this commercial kitchen is operated. It's completely outdated. Does not have any fire protection mechanism, infrastructure, to curb any incident that may arise from any fire hazard. Fire extinguisher is not there. The commercial gases that is required to run a commercial kitchen, nothing is there.
Who is appearing for the state?
But I'm for the state.
Yes. What is your instruction?
Made our best effort to collect the instruction, but that has not come. So, what I'm saying, that since he has made a representation let it be considered, my lord, and the authorities make an inspection. If they found, they will take the penal measures. And if they have the proper document, what will be the situation?
Your Lordship, may I?
Yes.
Your Lordship, I'll file my opposition regarding this because I am having all the safety measures we have.
You produce before the authority. I am directing the representation. It is an allegation that you are running the commercial kitchen in the premises without having these the
Fire
safety
safety
and
certificate.
without any license, without any.
We are
thing.
having all the
So
safety measures, Your
he
Lordship.
has made a request to the authority. Authority are not considered. The authority will consider giving a notice to all the concerned persons. You are having all the documents produced before the authority. And
My lord, I just add to what my learned senior standing counsel has said. My lord, let this repetition be treated as a representation with the authorities.
So you mean to say that the writ jurisdiction be given to the authority by sending the writ?
No, my lord, I'm not making this submission. Lord. Kindly permit your lordship. The content of my application.
The petitioner has filed the present writ application. London Council appearing for the respondents number. Madam, you are appearing for
7 and 9, Your Lordship.
7 and 9.
Yes, Your Lordship.
Respondent number 7 and 9. Submit that the respondent number 11, 13, 15 and 16 have passed away, but the petitioner has filed the present writ application against the dead person. And counsel for the petitioner submit that the respondents number 7 to 21 are the partners of the respondent number 6, and as such partners of the respondent number 7, and as such he prays for deletion of the name of respondent number 11, 13, 15 and 16. As per the submission made by the counsel for the petitioner, name of the respondent number 11, 13, 15 and 16 has been deleted from the cause list of the instant writ application. The petitioner has filed the present writ application praying for a direction upon the respondent authorities, particularly the respondent number 3 and 4, to take appropriate action against the private respondents for illegal operating the kitchen in the ground floor at 3 Biplapi Anukul Chandra Street, Kolkata, without any fire safety certificate and other required permission from the concerned authorities. Counsel from the police. Then counsel for the private respondent submits that prays for time to file affidavit in opposition. The land counsel for the state submit that as the petitioner has already made the representation to the concerned authority, if a direction is passed by this court, the authority will consider the representation of the petitioner after giving an opportunity of hearing to all the parties and take appropriate steps if it is found that the respondents are running the kitchen without any permission and without any fire safety. Had the learned counsel for the respective parties produce the materials on record. The grievance of the petitioner in the present writ application is only that the private respondents are running the kitchen in the premises in question without the fire safety measures and without any appropriate license and certificate from the concerned department.
Fire safety certificate.
Certificate and
fire safety certificate. Fire safety certificate is a document that you require.
Fire safety certificate and other certificate from the concerned authority for running the said business. Full stop. This court also find that the petitioner has made representation to the authorities from time to time, but the authorities have not taken any steps in respect of the representation submitted by the petitioner. Accordingly, the petition is disposed of by directing the respondent number 3. Respondent number divisional fire officer or the Director General West Bengal Fire and
Respondent number 3.
Respondent number 3. And what about the municipal corporation?
Municipal corporation.
Respondent number 3 to consider the representation submitted by the petitioner after giving an opportunity to the petitioner as well as the affected person, if any, if any, and to pass appropriate pass reason and speaking order within a period of 6 weeks from the date of receipt of this order.
Grant us the ability to supplement our with some relevant document on law.
It is made clear that this court has not gone into the merit of the matter, and petitioner and the other affected person, if any, shall also liberty to file further document before the respondent number 3 at the time of adjudicating of the issue raised by the petitioner.
So grateful, my lord. So grateful.
Aaya kya?
4.
But
Yes.
I made my submission, my lord. This is on the question, my lord. Will recall, my lord. There was a demand which was made, my lord, in 2011.
Yes.
My lord, in respect of 2011, which was, my lord, finally, my lord, quashed, my lord, by an order of 1st December 2017, saying that you can't be a judge in your own cause. My lord, we had, my lord, 3 tenders, my lord, which were doing, my lord. We were, my lord, providing, my lord, transport and, my lord, transportation to the, my lord, container freight station. Handling, my lord, the transportation, my lord, for the container freight station. Then, my lord, it got taken over by the land port authority, my lord. That's why, my lord, the contract was terminated. Thereafter, my lord, again, my lord, in the last contract, my lord, what was there, my lord, the 85 lakhs and 42 lakhs. Again, my lord, they encashed the bank guarantee, and my lord, they also not given back the honest deposit. So, my lord, on the last occasion, my lord, wanted to hear from them as to, my lord,
Yes,
what is.
Well, my instruction is, my lord, it is a fact that there is an embargo by virtue of the order dated 1st of December, my lord. My specific instruction is that it has not been adjusted. There's an appeal which is pending, which is challenging the order of the 1st December 2017. That is carried up in an appeal. The appeal is pending, my lord. We are making all endeavors to get the appeal heard out. Now, my lord, since the appeal is pending, we are just securing this amount because this bank guarantee, you know, it was about to frustrate within a couple of days, due to which we had encashed it. We had also allocated in a separate account. We have not adjusted against the amounts. I've also requisitioned the accounts from the department, my lord. The fact that we are awaiting, otherwise what happens, my lord, if we pay the amount right away, and in the appeal, let us say, my lord, we succeed. In that case, we have to now again proceed in a further proceeding
Okay, you
to
do
recover.
one thing.
Yes.
You deposit the amount.
Yes, yes, we will do that.
Registrar General of the
We will do
our
that.
Registrar.
Lord, may I just
We will do that.
point out one thing? Lord, they had made a stay application, Lord, in the appeal. Lord, that stay petition was dismissed. That's 593. So they can't, Lord, circumvent, Lord, the order of the appellate court and, Lord, take it, Lord, unto themselves, Lord, to
Then
work as if, Lord, they have a stay.
get the stay from the appellate court, then how you can retain the amount?
Amount should not be retained, Lord. Can
My lord, if your lordship directs, we will deposit it with the.
How you can retain the amount? Now, not the situation is stay.
We will keep it, Lord. Obviously, Lord, succeed, Lord, then I will have to give it back. If they at all succeed.
Because my lord, that would be a difficulty, because again we have to lodge on a different proceeding for the recovery of that.
How you can say it, sir?
My lord, if it is kept with the registrar original side, my lord, it will maintain equities. It will maintain equities.
Lord, 85 lakhs and Lord, 42 lakhs. 85 lakhs, Lord, was the bank guarantee, and Lord, 42 lakhs, Lord, is the honest money deposit, Lord, which Lord was there. So they are also that not returning that. And Lord will find Lord the orders. Lord, the kindly see Lord page 577 and 587, Lord, is the 1st December 2017 order.
577.
Yes, Lord, that's volume 5. And it was specifically held, Lord, that they cannot.
This one.
And my learned friend has been fair in saying that they really have, Lord, it's against Lord, the embargo.
That, my lord, I will not submit otherwise. It is a fact.
And my lord will find, my lord,
591.
Yes, 588, 589. Correct, 591. In such circumstances, rescission render impugned order. The order was what? That they will adjust. Cannot be enforced. The same is set aside. Parties are at liberty to avail of the remedies in accordance with law. This was not in terms of the arbitration agreement which was there. The other contention respondent need not be decided upon the same prejudice the parties subsequent proceeding that may be had. In any event, any event should be given the view taken on the subject dispute between the parties. No decision required to end other points.
This order is under challenge.
Yes, my lord. This is under
and then, my lord, this order is under challenge. Then, my lord, kindly see 593. December 2019. Then 594.
2017.
Yes.
Appeal of 2018.
Yes. And now, Malad, and after that, Malad,
The adjustment.
is also barred by limitation. And Malad, this contract, Malad, was entered into, Malad, in 2020.
In regard to the learned judge has passed the interim order while the entertaining staying the recovery of the replacement ultimately Yes.
So there's no question they can't overreach the order of the court.
This court earlier already vacated the stay order by passing this order, and division bench is not how you can.
This is, my lord, this is the fag end of hearing, my lord. I will not say anything because, my lord, the conduct is
done.
the conduct
This
is bad.
This
submit.
court also cannot pass up, go beyond the order.
True enough.
That-
True enough. True
As
enough.
your hand is tight, my word is tight here. I cannot pass any further order after this division bench order. Division bench has not granted any stay.
Any state has not been.
So, what is your prayer?
My lord, my prayer is, my lord, for the purpose of
Refund of my amount.
Yes, my lord, page 39. My lord, I have asked for refund of the security as well.
What is your challenge?
My lord, challenge is, my lord, to the
New
invocation.
order has been issued. Where is the order? 2017 February 26?
Yes, my lord, February 17, 2026 is, my lord, page 607.
Encashment of bank guarantee.
Yes, and kindly see what do they say. This has reference encashment of bank guarantee. This is reference to the subject cited above. It is to inform Phoenix Traders Private Limited as a service provider for cargo handling at CWC Petropol with effect from kindly see 1st March 2020 to 17 May 2024. This was in connection with the subsequent contract, and that order was passed in 2017 and 2019. For the aforementioned contract period, Phoenix Traders submitted bank guarantee rupees 85 lakhs for performance security. As per available records of the office, an amount of this is the same amount. 3 crore 49 is receivable from Messrs. Phoenix Traders. With the approval of committee, has been decided to encash the full amount of the bank guarantee, 85 lakhs. Therefore, request to encashment sunset, dated sunset, full amount is transferred. And we objected to that, which is at page 611. Where we said return as the bank guarantee. At 613, will find. Facts leading to the present dispute, 613.
Yes.
We awarded a contract by CWC for transportation of ISO containers, such and such, and with effect from 25th June 2006. This was the first one. The dispute arose in relation to recovery of alleged service tax amounting from us for the period 1st 11/2008 to 31st May 2011, covered under the first contract. It was the case of CWC that released service tax in our favor erroneously for and sought recovery thereof. Consequently, CWC issued a demand notice requiring us to make payment of 3 crore 49 within 15 days. When it proposed to adjust the same for the bills received by us under the second contract. Being agreed, we filed WP number 10468, 2012 before the Honorable High Court. Writ petition was disposed of and order dated 17 May 2012, directing regional manager of CW grant as hearing pass a reasoned order. Thereafter, order dated 21st June 2012 was passed, directing adjustment of the alleged service tax amount from our dues under the second contract and purported ground that the amount was outstanding and payable by us. Then 614.
Yes.
So they can't repeat the entire exercise again. The said order, page 614. Same thing, the said order dated 21st June was challenged before the Honorable High Court, Calcutta, period dated 1st December 2017, which is what I showed, 619. The Honorable High Court was pleased to set aside the said order and categorically held that CWC cannot adjust amounts received under the second contract against alleged liabilities under the first contract, which had already expired. Now we are on the third contract. The said judgment has been challenged by CWC before the division bench. They also filed a stay application before the division bench, which was rejected with the order dated 10 December. Thus, the operation of judgment dated 1st December continued to bind the party. Here to annex order dated 1st December and 10th December. However, no stay has been granted against the operation judgment. Same continues to bind the party.
And this demand is the earlier one?
Yes, same one. 3 crore 49, my lord, of 2011.
11. So now they are claiming 85.
No, 3 crore, my lord, in lieu
of this.
Yes.
The what the 85 is lying with the new context
Yes.
that they wanted to be
85 and 42 is lying with them. So they again want to adjust it in lieu of 349, whatever is.
Okay. Order. Tomorrow for orders.
I'm grateful. Obliged. And my lord, 42 lakhs is also there. That letter is also there.
Yes.
My lord, I'm sorry. Just my lord, if my lord notes, my lord, 42 for the 42 lakhs. That is my lord at page 633.
That's the EFT.
The security deposit also they are not releasing.
Requested to refund the security. This is a different one.
And the same contract. So there are two amounts. One more 5 lakhs. And Mala, this is the security deposit of 45 lakhs, which will now become 42 lakhs.
42 lakh, 53,000.
42 lakh 53,000.
Yes, correct.
010.
Yes.
Yeah, there are two amounts.
Yes, two amounts.
Correct.
Two amounts.
So that is with regard to 850620 and 4253.
Correct.
Total 127.59.30.
Yes. I'm grateful. Lord, tomorrow, my lord, I'm not there. Kindly excuse my presence, my lord.
Orders, I
Yes.
Tomorrow.
I'm grateful. I'm extremely.
Tomorrow or day after tomorrow we'll see. Or Monday.
Whatever.
Let me Monday. Hearing concluded for orders.
For orders.
Let us see if tomorrow I will deliver tomorrow.
I'm grateful.
Yes. My lord, in this matter, my lord, I am appearing on behalf of the respondent. My lord, may kindly recall, my lord. In this matter, on the last occasion, I challenged the maintainability of this writ petition on the ground that this writ petition lacks the territorial jurisdiction. This honorable court lacks a territorial jurisdiction to entertain this writ petition.
Yes.
Because of the fact, my lord, the case of the writ petition that they have been served with a notice by the bank for fraud, for declaring them for taking steps under the fraud act or fraud circular, my lord, and the petition, it was served from Chandigarh. The accounts in question are in Chandigarh, everything or in Chandigarh. The registered office of the petitioner is in Calcutta.
Where the bank guarantee of
Chandigarh. I have so my lord, my lord was pleased to allow me to make submission before the petitioner, my lord. Why I am saying this, my lord? My lord, kindly sees the averment that they have made, my lord. First, my lord, kindly sees the notice impugned, which they have.
Where is the notice?
My lord. At page 77, my lord.
Where declaration fraud?
Yes.
Yes, my lord.
So my declaration will take effect here. Wherever my bank guarantee is given, my lord. That is the ratio. 226.2 is the principal.
Yes.
My lord. Page 77, my lord. My lord, kindly sees Sri Aditya Balasaria, guarantor of Mrs. Venus Pharmaceuticals, Pharmagenics Private Limited of AGC Bose Road, 3rd floor, entrance through Lord Sinha Road, Kolkata 20. And my lord, kindly sees the address of the bank issuing that at the bottom, my lord. Fraud Monitoring Cell, local head office, sector 17A, Chandigarh, such and such. And my lord.
Where is the bank address?
My lord.
Where is the bank address? Such a fraud.
Fraud, my lord. My lord, kindly sees the averment that they have made, my lord, at page 26 of the writ petition, paragraph 56, my lord.
Paragraph 56.
Page, paragraph 56, page 26.
Yes.
We did the communication dated 22nd October 2024 issued by the respondent number 2 in his alleged capacity as Assistant General Manager of the respondent number 1 purporting to be a notice under the Master Circular dated 15 July 2024, which was received by the petitioner at his address at Kolkata, and the respondent has threatened to take measures against the petitioner who is a resident of Kolkata. As such, this, my lord, this is not a company also. The petitioner has filed this in his individual capacity. So petitioner is having his address at Kolkata and he is the resident of Kolkata. and he's received the, as such, this honorable court has jurisdiction to entertain the present application.
Where is the where is the loan?
In Chandigarh,
I am not the
my lord.
Then,
my lord, kindly cease, my lord. My lord, my lord, whether the alleged cause of action is having any proximate or any some relationship or any such part cause of action which is having some proximate relationship with the issue has arisen in the state of Kolkata. My lord, kindly cease. May I? This is a very old judgment, not reported.
it is a so-called notice or order?
No, show cause
So-called
notice.
notice.
My lord, this is a আগের দিন দিয়েছিলাম জজ সাহেব আবার নতুন করে হচ্ছে অনেকদিন পরে শুনছেন না my lord here what happened my lord if kindly sees the first paragraph barring the head after the head note an application under article 226 of the constitution my lord has got constitution of India was moved by the appellant company. Its contention was that Bihar trade Articles License Unification Order 1984 and Bihar Essential Commodities Order 1977 were ultra vires and the said orders did not in any manner affect the business carried on by it. The submission made on behalf of the appellant, whose writ application was dismissed by the learned trial judge, were that the impugned orders and the notification has seriously affected or were likely to further affect the business of the appellant with its consumer and purchasers in West Bengal, and that the part of the cause of action arose within West Bengal where the appellant had its offices. The respondents urged that this court had no territorial jurisdiction to entertain the writ petition. That was the moot contention in this writ petition for which this decision was rendered. Now, my lord, may I take my lord to the second last page at page 447 of this order. Thus, if my lord has got page paragraph 13, last paragraph. Thus, even the allegations made in the writ petition filed by the appellant are true. They indicate that there may be remote or indirect consequence upon the petitioner at its office situated at Calcutta. Neither of the two orders imposed by the appellant any liability or obligation to be discharged or performed at any place within the territorial limits of this court, that means Calcutta, merely because the appellant feels the consequence at its Calcutta office of the enforcement of the said aforesaid to order Bihar orders, same is neither proximate nor direct in nature. So, my lord, an order was passed, not only an order, it is not even an order, a show cause notice issued for taking steps for declaring the said person, not even a company, a person, an individual, as fraud, was issued from Chandigarh. Every loan bank transaction took place in Chandigarh, in the state of Chandigarh. He only asserts that he is a resident of Calcutta and he has received the notice in Calcutta. So this Honorable High Court is having jurisdiction. Now, my lord, this notice, whatever notice has issued, whatever decisions will be taken, not in Calcutta, my lord, everything which happened, which gave rise to this cause of action, alleged cause of action, has arose in, my lord. This judgment of Alchemist, my lord, of the Honorable Supreme Court of 2007, my lord.
Fixment.
Alchemist now.
How much time will it take? My fixed matter is there.
We'll fix this matter on some other day, my lord, pleases, because it will take, my lord, I may, in my humble way,
My learned friend had
will
made these
take-
submissions, my lord. I
I will
wanted
take
to
at
just,
least 15 minutes, my lord, subject to, my lord, sanction, my lord.
Not today. Not today. No, no.
My lord may fix it any date as my
Not
lord
today,
fits.
tomorrow, my lord.
My lord is, my lord, be pleased to keep it in top, my lord, because we are, since and.
Then I will take it after 4:30. If you say the top either 4:30 or 9:30. I will fix at top.
Actually, what happened, my lord, since the writ petition is pending, so since they have filed a writ petition, whatever reason may be, we are not proceeding, we are not in a position, no, there is no order of stay, nothing of that sort. So that is the reason, my lord.
Come tomorrow, if time permit, I will hear you. No problem. Learned counsel for the respondent has argued the matter at length regard to the maintainability, but the hearing could not be completed. Please the matter tomorrow.
But if it is possible, your lordship can fix any date, my lord.
Date, then it will go to the August.
August.
That is the problem. After 4th August. You are ready then?
Before that, my lord, there is.
No. That's why I am not fixing the date.
Very well. We shall take our chance, my lord.
Now for the plaintiff, my lord. Well, in the last occasion, I had already given a brief overview of the matter. This is an insurance claim where loss was caused by fire.
Yes.
And the basic features, undisputed features of this matter is that the facts which are admitted is that the fire occurred. I suffered a loss. The location where the fire occurred and the goods which were damaged by fire were covered under the policy. I was offered, the loss was assessed, quantified by an insurance surveyor, and that quantification was accepted as proper and right quantification by my client as well as the insurance company. But the insurance company, after 12 years, more than 12 years, deducted 25% of the assessment of loss done by the surveyor.
Yes.
And since the plaintiff raised objection regarding this 25% reduction, called upon the insurance company to pay the 75% as by way of provisional settlement and to go for litigation for the rest of the 25%. The entire claim is held up. Facts. The coverage of loss and the quantification of loss is not in dispute.
Yes.
It is only about certain allegations made by the insurance company. Deduct 25% loss assessed.
Yes.
Now, my lord, and it is an undefended suit, my lord. So, therefore, my lord, since it is undefended, I have an additional duty to show how I proved. I will indicate the relevant portions of the pleadings and the evidence in support of that, and also indicate that my pleadings and evidence were not controverted in cross-examination, were not put to tested in cross-examination. Now, my lord, kindly, I had handed up a convenience brief to your lordship in a spiral-bound book.
Yes. Yes.
Now, my lord, your lordship kindly sees this. The first document is the plaint.
Yes.
Now, my lord, kindly, skipping paragraph 1 to 4, paragraph 5 is that I had obtained two policies. One is fire, one is marine, a marine package policy. Now, my lord, here, before I go into these pleadings, I must indicate that there were claims in respect of the same premises. Some portion of the goods were covered under fire policies, portion of the goods were covered under marine policy, marine package policy. So for the goods which were covered under the fire policy, they are also that also got the same fate after 12 more than 12 years, settlement. And that was, since in that policy, fire policy, there was an arbitration clause, matter was taken to arbitration, where an award was passed in favor of the claimant, plaintiff here. And that is under challenge under section 34. Now, my lord, here, under the marine policy, there is no arbitration clause. So we had to come to commercial suit. So paragraph 5 is about the detail of the policy. Now, my lord, kindly come to the next page. Paragraph 6 speaks of how the fire had taken place and what were the actions taken by the claimant as soon as the fire was noticed. Plaintiff, as soon as the fire was noticed. On January 6,
So
2000.
not file the written statement. What is the cross-examination?
Statement on
What is
this.
the cross-examination?
My lord.
Come to your witness evidence.
Yes, my lord.
I will
I'm
go
coming to the cross straight away.
I will go to the pleading, you come to the examination in chief of the party.
Yes, my lord. My lord, chief was through affidavit, my lord.
Okay, and what is the cross-examination?
My lord, kindly
And
comes
what
to
are the document you exhibited? You are proving your case.
my lord, list of exhibit was perhaps handed up to
Yes,
your
that is
lordship. Okay, listed it to that.
Yes, it is there.
Yes, my lord. Now, my lord, kindly see the list of exhibits.
Where is the PW1 cross-exam? What is the trend of the cross-examination? So the
my lord, page 70. Page 78. Cross-examination starts from (107) in the convenience brief, my lord.
Yes. Cross-examination of plaintiff witness.
It starts from 287. 287 to 287 to 296 pertains to our questions regarding the competence of the witness.
Correct.
It has nothing to do with the facts of the case, my lord. Kindly comes to 297 at page 108.
Yes.
Your alleged claim under the insurance policy arises out of a purported incident of fire. Can you indicate the specific address of the premises contained that the alleged incident of fire has occurred? No, he checked the records because it's a very old case and he testified to the address. Now, regarding this question, location of fire was never offered. And described which were alleged to have been destroyed in the purported incident of fire. Now, this was also accepted because 75% for the same reason settlement was offered. It is a quantum dispute.
Yes.
Neither coverage nor insurance interest petition question. Described in the answer to the earlier question of and backlit. These are plastic composites. Now, my lord, pausing here for a moment. This question is very important.
Yes.
Rather, it will put one case. This question and answer. Shown page 1. The documents show subject to insurance policy by suit. Yes. Stating that 301 insurance policy at transit. This policy covers goods in transit as well as stocks in warehouse for 8 weeks.
Yes.
Stating that the goods which were stored in safe in transit, stored in safety warehouse were in transit. Finally, indicate the distribution of the said goods. Now it was subject to objection, my lord. I have to check the records. Now, regarding the input of these goods, surveyor had made description and surveyor had quantified. And the surveyor can transport the said goods. This was also subject to objection. I have to check the records.
Yes.
It is no way relevant because the trend of these questions are
Yes.
indicating the validity or genuineness of the claim.
Yes.
Company.
Yes.
Can you name the transporter? Then 305. Kindly check the records and answer to question number 303 and 304. Answer to question number 303 is that the paper is China also from the levels of Jupiter. And answer to question 304 is matter is that the matter is too old and unable to answer at this moment. 306. Are you in a position to say transport transporter hired by private companies? These questions are in no way relevant to this because scope of this litigation is very admissibility of claim is not in dispute. Can you disclose the approximate volume of the plaintiff company was exporting in the incident of fire took place? Now, these are also thoroughly verified by the surveyor.
Yes.
And whose recommendations, assessment, quantification of loss and admissibility or liability has been admitted by the insurance company. Kindly indicate how many I have to check the records. Now, this question is also not pertinent because this go down was covered, admittedly. Kindly check the record and answer the question number 308. The number of the check the records. Will I be correct in saying that the company have other goods at its disposal? Was the 6? Yes. 311. Do you remember the company had its disposal? Can you the company the company's officers yes. Are you now posing firefighting equipments were there or not, that question is not pertinent. I will explain why when I go on the legal interpretation of the policy. Now, my lord, in insurance policies, because insurance policies are drafted policies. That's why the contra profile is applicable in case of insurance policies. These are standard form policies, drafted policies. That insurance company at its option has right to insert conditions, additional conditions, and additional warranties. For an insured, it is take it or leave it matter. Now, that's why the second law, it is not only second in India, it is because insurance law in our country has come down from mostly the British insurance laws, and our Marine Insurance Act is also a replication of the British Insurance Act of 1906. It's a replication. So, my lord, it is a settled principle of law and has been that an insurer policy. If a condition or policy, there will be a question of breach. So why I paused this question, the trend of the question, as I understand, was to show that there was some breach as a client is not supposed to insurance litigations I am aware of. The insurance type, which is a document, insurance companies.
Insurance policy was exhibited.
Kindly comes to exhibit number 1. Page 1 to 4. JBT. Policy.
Now, in a godown, my lord, it is a condition precedent that we should not have electricity connection.
Who? JBT doesn't. My lord, kindly sees page 5. It starts from page 4. No. I'm sorry, my lord. It starts from page 1 is a covering letter by which the policy is communicated. Now, it starts from page 2, my lord. JBT volume 1.
Yes.
Now, my lord, kindly see, a policy has two parts. One is the policy schedule, that is client specific. Description of the client, and the second part is standard terms and conditions. Now, my lord, kindly see the policy schedule. Risk covered, all risk.
Where from you?
My lord, kindly see in the middle of the policy at page 2.
Yes.
My lord, risk covered. After total sum insured, there is risk covered. All risks as per ICCA and inland transit, rail, road, air. Now, my lord, here, all risk policy has a special feature. In any of the insurance policies, commercial insurance policies, there are two types of policies. Policy, and one is all risk policy. Example of main is like fire and special perils policy, where 10 types of risks are mentioned, and if the loss is covered by this mentioned.
Sir, the only question why you are wasting so much time giving the lecture, the only question whether the pure policy is in consonance with the terms and conditions of the condition, because they have taken only stand that the godown which you have kept the materials consisted by the side there was a generator side along with the kerosene. Because of that oil, this incident was occurred. That's why you are not entitled for that. Where is the document to prove that observation of the dependent, or you have disproved that? That is the only.
That is in my plaint. So, my lord, should I indicate
the
the policy?
last 3 days you are repeating all the things. You come to the specific place, which is the defense, the only one defense with regard to the report of the survey.
No, my lord. Repudiation letter, my lord.
That's why repudiation letter. Why it has been repudiated?
Yes, my lord.
Because of that report only.
Yes, my lord.
Diesel, because the high flame was there. And diesel was used, and that's why there was a high flame, and you are not entitled to that.
Then I will start.
You have not examined the expert to negate that report. So how you can negate that? And you exhibited that report.
My lord, I'll show.
Once you exhibited that report of your own, how, and you have not examined the person who has submitted the report, so how you can ventilate your grievance now?
No, my lord, I will indicate that.
So, come to the report first.
My lord, kindly comes to the plaint, my lord.
Plaint, no, you see, this all the things are evidence.
My lord.
You have to disprove because they have repudiated your claim on the basis of the report. You have to disprove the report, but you are not called for the
My lord.
expert for denying that.
My lord, may I? My lord, so far my understanding goes, as per the law laid down by the Honorable Supreme Court and all other courts, if insurance company repudiates my claim, the onus of proving the ground of repudiation is on the insurance company.
Correct.
You have to prove.
Correct.
My lord.
But you have to deny it, but you have made the blunder at the time of examination, which the report has not served to you. You have exhibited the document. What remains for approving by the insurance company? You have done the blunder by bringing that report exhibiting. Once the report is exhibiting from your side, why the insurance company will prove that?
My lord, I have exhibited the existence, my lord, but
report
marking
report is against you.
My lord, absolutely. But marking a document of exhibiting a document
From
does
your
not.
side, if it
My
is
lord.
their side only exhibited, they will not examine. It can, and you're denying in the
My lord.
cross examination, then it is the duty of the party to prove.
My lord,
You have brought the document of the other party, so where is the
My lord,
necessity?
I have also brought the document of the subsequent report, which is also a third party report, my lord.
Sure.
My lord. And which is in our favor.
Examine only one witness.
My lord.
What the witness say? He is not the witness to the incident. He is not the expert. You have not called the expert. You are arguing for the last 4 days.
My lord, may I
On fact, this case is only based upon the report, and you.
My lord, this case is.
Please, you
I will
get
indicate
ready on that. How you can come out from the
My
report?
lord, I will indicate two
Show me
documents.
that.
Kindly see, my lord. My lord, but I have to show the plaint once, my lord. One paragraph of the plaint.
Plain nothing.
Well, my lord, I'll.
You justify first this court with regard to the report on the basis of which they are repudiated. How you come out from that report?
Well, I'll show, my lord. Insurance company has not relied on that report. I'll show, my lord. Kindly see the report, Exhibit W.
So that Exhibit W.
And I will show, my lord, I'll also indicate why I was going into the conditions of the policy. Why I was explaining all these policies, that even if your lordship goes by the report of screen facts, then also my claim is covered.
That's why I'm telling, address on that issue. Even though you are admitted that report, you are entitled to. That's nothing else.
My lord, kindly see, my lord.
Because there is nothing on cross-examination. That's why I told you, show the cross-examination. They have taken that plea only. That is the plea they have taken. There is no other plea.
My lord.
And that document, that's what I'm telling. You have brought that document on record. I don't know why.
My lord, under Commercial Courts Act, I have to disclose all documents in my disposal. Now, my lord, I have.
Disclosure is different thing, exhibiting different thing.
My lord, but
disclosure will not judicial notice will not been issued, not been considered at the time writing the judgment unless and until it is proved.
But so far, my lord, a document marking exhibit of a document,
yes,
it does not automatically prove the contents thereof.
Please, again, I am telling, it has been exhibited by you of the document of the defendant. So where is the necessity of the proof? Admitted document cannot be proved.
My lord, existence of the document, my lord. And
you have brought that to existence of.
My lord, may I come to the document?
The clever advocates will never admit any document.
My lord,
if you wanted to prove that.
My lord,
but you have made the blunder on that. I don't know if you will come out from that.
My lord, my lord,
come.
I will satisfy your lordship that this document also saves me.
Page 38.
No, my lord, 307, my lord.
The report.
It is in 307. Judge's brief. My lord, may I straightway coming to the relevant portion of the report, my lord?
Yes.
It's a longish one.
Yes.
310.
Yes. Second paragraph.
Sir, the forensic experts, my lord, and this is not the forensic report, my lord. They are only quoting the forensic report, which is neither here nor there.
That's what I'm telling. Show me.
The forensic experts in their report number so and so dated
22/2006, addressed to the Deputy Commissioner of Police, Port Division, Kolkata, gave their valued opinion that the incident of fire on 5/6/2006 at the godown at 6 Garden Reach was an act of arson. Now, my lord, kindly note this. Forensic FSL had said it is an act of arson. Now, pausing here for a moment, arson is covered under the policy.
Correct.
Upon this report of forensic expert, police registered a case of arson against the unknown person under section so and so, white PS case number so and so. Now, my lord, next para I am coming. The forensic expert in their report number so and so dated so and so described the fire as an act of arson. Now, kindly, my lord, again, reiteration, it is an act of arson. The expert arrived at this finding after examining the scene of fire as well as examining the sample of traces collected by the police from wreckage of the godown. The expert found presence of highly combustible foreign substance that alone was responsible for heightening the heat and temperature of fire to over 1000 centigrade. As because burning of computer parts and peripherals stored in the godown cannot produce that much of temperature which caused conversion of ferric oxide into bricks. So, my lord, this is the finding of the forensic expert. Now, my lord, this is again repetition. If your lordship desires, I will go through the entire report, but this is the crux of the report which I have read out.
Correct. Okay.
Now, my lord, kindly see the date of the report. Date of the report is 5/8/2007. এবার যে বসিরের অ্যাপয়েন্টমেন্ট সেটা লাগবে 5/8/2007. So, my lord, this report was not disclosed to the plaintiff.
Which report?
This report which I have read out, this Premier Vigilance, private investigators report. FSL.
That's why this page, the Exhibit W.
Yes, my lord.
Exhibit W is also vigilance report.
No, my lord, it is a private investigators report.
Private investigator.
It is quoting FSL report which is not on record.
Correct.
That is not disclosed to us.
Correct.
So, this report, the plaintiff had objected to by writing a letter.
Where is the pleading with regard to this in your plaint?
My lord, this is what I wish to show to your lordship.
Where is the pleading with regard to this Exhibit W?
My lord, I am coming to that, my lord. My lord, kindly comes to paragraph 9 of the plaint. 9 and 11, these are the two relevant documents. Two document paragraphs. And my lord, I will show from the documents of the insurance company, they have not relied on this report for 12 years. Rather, they wanted further investigation, which they had. And which report, the further investigation report is in my favor. Now, insurance company has gone on report shopping until and unless a favorable report has been received by them. And that is also, my lord, contrary to the IRDA regulations, which is statutory regulations. My lord, kindly see paragraph 9. The surveyor had processed and assessed the quantum of loss caused by the aforesaid incident for indemnity under the said Marine All Risk Cargo Package Insurance Policy. In the meantime, the police authorities had investigated the matter involving the Forensic Science Laboratory, Belgachia. FSL allegedly opined inter alia that the incident of fire was arson. The police authorities reported that no one could be apprehended in connection with such arson. Accordingly, the fire was closed by the police authorities. Now, my lord, kindly comes to paragraph 11. In 2007, defendant appointed Premier Vigilance Security Private Limited to investigate whether there was arson in connection with fire loss at godown. The said Premier Vigilance and Security Private Limited submitted its purported report to the defendant on 5/8/2007. It is also stated in this regard that the report of the said Premier Vigilance was in sum and substance a mere replication of the report of the Forensic Science Laboratory, which in itself is flawed and speculative. The said purported report of Premier Vigilance Limited and the report of FSL were not furnished to the plaintiff by the defendant when the defendant had obtained the same, and the same was shared with the plaintiff at much belated stage. The defendant did not refer the matter to the surveyor despite...
Where is the reputation?
My lord, kindly see 12 and 13, my lord.
I read before your reading, I read.
My lord. Now, kindly give me reputation.
Where is the reputation?
ওখানে লুজ কপি আছে না আমি জাজেস ব্রিফ থেকে বলে
এটা অরিজিনাল
My lord, for your lordship's convenience, I had given a loose copy of the for marking and all. It is 401, my lord, judge's brief. Now, insurance company did not rely on this report. They wanted further investigation. And that investigation happened as per the direction of this Honorable High Court, a division bench. And that investigation report is in my favor. My lord, kindly sees 401.
Yes.
We referred to your claims under policy number so and so. My lord, kindly ignore the other policy, which is fire. The surveyor, Mrs. J.B. Boda, inspected the laws for marine and fire policies. My lord, kindly see from paragraph 5, my lord. After studying the survey report, we had appointed Mrs. Premium Vigilance and Security Private Limited as investigator to find out the details about the cause of fire in order to supplement the survey report. Brother, the said investigator submitted his report wherein they ruled out an accidental possibility of fire and firmly stood by the opinion of presence of foreign highly combustible substance in the godown. My lord, kindly, my lord, appreciate it here. They are relying on that report, but taking a piece out of context. Very conveniently, inflammable substance due to arson aspect is removed. The Premier Vigilance report speaks of an FSL report purportedly speaks of arson. Somebody has torched the location by putting fire and inflammable substance. Now he says that there was presence of inflammable substance. The arson aspect is omitted deliberately. And arson is covered as malicious damage under all risk policy as well as fire insurance policy. Now, my lord, kindly see, if they rely on a report, this Premier Vigilance report, they have to rely on the report on its entirety. In order to ascertain more facts, my lord, kindly, this is important. It is in order to ascertain more facts on the point of arson.
So, where is the report of the Phaguni Purkayasta?
My lord, that is in page number, it is in the last volume, my lord. 376. Volume 3. It is in volume number 3, my lord. It continued to volume 4 also. I think it is, no. In same volume, my lord. My lord, before your lordship goes to the Forensic Science Laboratory report, my lord, kindly comes to paragraph 374, page 374 once, my lord. That is a judgment of the Honorable High Court.
Yes.
My lord, 374. I am reading the operative portion, my lord. We have heard Mr. Mitro.
Yes, on the basis of the report, the Prokasta was appointed.
Yes, my lord, as per direction of the Honorable High Court and IRDA.
Correct, and and you have not raised objection. But subsequently, the Prokasta report, they are not believing on the report of the Prokasta.
Yes, my lord. Now, my submission is that after conceding to the Honorable High Court that new experts should be appointed through IRDA, and after such investigation report not going in their favor, they cannot go back to the Premier Vigilance report, which they had not acted upon for 12 years.
What about the FSL? Where is the FSL report is exhibited?
My lord, FSL report is not with us.
It is exhibited or not?
No, my lord.
Okay. FSL report is not exhibited.
Not exhibited, my lord. It is not disclosed also. Insurance company has not disclosed it. Now, my lord, kindly comes to the Falguni Purokastu report.
No, they are not relying upon. In the reputation, they are not relying upon.
Yes, yes, they are, my lord. Now, they are saying this report is flawed.
See, kindly paragraph 10.
Yes, they are saying this is report
Though the
is incorrect.
investigation report is not convincing because of unproven statement.
Now, my lord, kindly appreciate insurance company, the person who has written this, B.R. Nayak, he is not an expert. I would have understood insurance company has appointed another expert to rebut the findings in this report. This gentleman is appointed through IRDA. He has to give reasons why this report is not convincing or this report cannot be acted upon. There is no reason. And he is acting upon a report which is 12 years old, and throughout 12 years which the insurance company has not acted upon.
Yes.
Now, my lord, kindly comes to the concluding part of the report of Falguni Purokastu. It is on record, my lord, and in my evidence, I have marked this as exhibit 398. এটা কোথায়? Volume 3 টা কোথায়? My lord, conclusion is 398. It is opined that FSL report indicating the incidence of fire as caused by arson involving human act has not been authenticated, as report is silent over source of ignition, as also presence of specific flammable liquids as accelerators as per requirement of indicators of arson. The test results specifying sample of burnt specimen drawn after 11 days are oxidized of iron, material of joist, which are oxidized ashes of building structure and not flammable substance whose burning melting temperature is highest compared to the stocks stored in the warehouse that was affected by fire. There is no reference of any flammable liquid such as diesel and the like or the other malice intention by anyone behind such.
As per the insurance policy, you only have to store the material which has been insured under the policy, or you can store other materials.
No. Only the, my lord, actually, in reality, all my materials are insured. So whatever is stored there is insured.
No, because they have taken the plea. They have taken the plea. We have believed that the unauthorized and undeclared, highly hazardous, unknown commodity substance were being stored in the godown by you.
No.
So my question is, just suppose you have taken this place as a godown.
Yes, my lord.
Correct. Godown might be it is insured, whatever it may be. You have insured the materials which has been transited from China. Correct.
Yes.
To Kolkata port to anywhere.
Yes.
So this policy is with regard to the materials.
Materials.
Correct. So materials which you have placed in the godown, that godown set in fire and your materials
destroyed,
and you claim. You have claimed. Now there is a dispute with regard to arson or with regard to flammable article, whatever it is. So whether as per your insurance policy, only the insured article is to be kept in the go down. If you have kept other go downs, you are not entitled to
Yes,
claim.
I understood, my lord. My lord, no insurance policy will say
Correct.
that.
So because the paragraph 10, line 4, they have one of the ground they have taken that you have kept the other material.
In the reputation letter.
Reputation letter.
My lord, I'll just
402, paragraph 10.
Should I?
What is?
My lord, I can answer, but it is. Should I continue? It is 4:30. That's why I'm asking.
No, I am asking.
Yes, my lord.
So whether if it is only that you can store that and other article cannot.
I can, my lord.
That
My lord, like I explained to your lordship, I have a huge go down. Some of my materials are stored there which are insured. There can be other materials which are not insured.
Not insured.
If there is a fire, only the insured item will be taken care of. But here this finding is also without any basis. Without any material basis, this finding.
Okay.
That I have stored other materials. It is the first person to visit the godown is the surveyor. He has not said I have placed anything inside the godown other than insured item. Surveyor, and they are relying on the survey report.
Okay, thank you.
My lord, if in this matter, my lord, if I give a little longer run time, I can conclude, my lord.
Nothing. I will hear Mr. Datta on the next day. There's nothing.
I have judgments to show, my lord.
Let Mr. Datta convince this court how
my lord,
the insurance company can repudiate that.
Our defense is very simple. We have acknowledged the existence of the fire and that the goods were there. But instead of paying the 100% of the claims, 25%, because we found that due to the fire, the iron pillars, the joists, they had bent and the bricks had turned black from ferrous oxide to ferrosulfuric oxide. I shall cite the literature. So this can happen.
But the problem is that report, FSL report is not exhibited.
FSL report has not been exhibited. But that has not been relied on.
And this other two report, the FSL on the basis of FSL report that has come, but the FSL report is not there. So how you can
at the same time, Mr. Purkastha was not examined by them.
Not examined. No, they are not examined, it's okay. But with regard to this FSL report on the basis of which
FSL report, my lord, we could not exhibit because the original FSL report, by the lapse of time, it got misplaced.
Not problem.
None of the officers could bear it upon himself to lodge a diary that this has been lost. Because the moment he does it, his job will be made.
Even if the report is there.
See, with regard to you can adduce the secondary evidence because
even if the report is not undefended suit.
That's why. Because that's the problem. That's why you want to hear you.
But the reports of the other investigating authorities, Premier and other one, they have been exhibited and they have relied on
the premium. FSL. They have relied upon the FSL.
Yes.
So FSL.
That is the base.
That is the case. The FSL relied, but the FSL report is not before the court. So how the court can believe on that? That is just. Come on. The next.
My lord kindly fixes a date, my lord.
A date, right?
August. My lord, could it be a little earlier?
Earlier after 4:30 or before 9:30? I have two times. You come before at 9:30 morning, I am ready. Or come at 5:30, 4:30. London Counsel for the plaintiff has plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 5th and 6th August at 3 p.m.
I'm deeply opposed, my lord.